Kim gave it to me. morning, everyone. There's a couple matters we need to make a record on before the jury comes in. And for the purposes of the record, the defendant is present along with his counsel and counsel for the state. Unfortunately, we have one of our jurors that has become ill. It was juror number 33. And by my notes, then juror number 48 would take the position or place of juror number 33. Does the state agree?
Yes, Your Honor.
And defense?
Yes, Your Honor.
All right. And then, Mr. Puentes, do you wish to make a record with your client as far as testimony this morning?
I do, Your Honor.
You may proceed.
Thank you. We're going to get you a microphone, Mr. Behal. As with last time, just to make sure the court reporter can hear you, can you just say something into it?
Yeah.
All right. So, you remember Friday afternoon, we had a discussion. I referred to it as a colloquy. Do you recall that?
I do.
That was done on the record like we're doing it now. Is that correct?
Yes.
At that point in time, I sort of walked you through your right against self-incrimination, correct?
Yes.
We talked at length about how the state, the defense, or the court cannot force you to testify if you should elect not to. Do you recall that conversation?
I do.
Did you fully grasp and understand the conversation on Friday afternoon?
I did.
But after having the weekend, it was brought to my attention there's been somewhat of a change of heart. Is that correct?
That is.
And I guess I'll just ask you frankly, has there been a change with respect to whether or not you wish to testify on your own behalf?
Yes.
And what is that change?
I would like to testify on my own behalf.
And are you certain with respect to your decision at this time?
Yeah.
And is that decision made knowingly?
Yes.
Is it made intelligently?
Yes.
And is it made voluntarily?
Yes.
Your Honor.
Does the state believe there's any further colloquy needed?
No, Your Honor.
All right. The court, based on the defendant's statements and the questioning by his counsel, makes the finding that the defendant has made a knowing and voluntary election to testify in his own defense. Is there any further record to be made at this time?
Not on behalf of the state, Your Honor.
I do want to say briefly, one of our witnesses, we kind of discussed informally, but has some issues at home. He is present, so we're actually going to call him first, and then we'll call Mr. Behal second. That's
all right. Okay, we'll bring the jury and then. You may be seated. Good morning, ladies and gentlemen. The defense may call its first witness.
Thank you, Your Honor. We would call Dr. Doyle.
sworn in, and then they're in the witness box.
All right,
Do you swear to tell the truth, the whole truth, nothing but the truth?
I do.
Please have a seat there. You may proceed.
Good morning, Dr. Doyle. Could you please state your name and spell it for the record?
Yes, my name is Al, A-L, Doyle, D like in dog, O-I-L-E.
And Dr. Doyle, you've your wife has recently had some health issues, is that right?
Yeah, for about 8 years, but it's been really bad lately, yes.
Okay. And typically we have a CV or resume from our physician, but we're going to go through that on the record due to the issues with your wife being in the hospital recently, okay? Does that sound okay?
That's good. She actually is still in the hospital.
Oh, she's still in the hospital. Okay, so are you a physician duly licensed to practice medicine in the state of Iowa?
Yes.
Are you also licensed to practice in the state of Illinois?
I'm sorry, state of Illinois is where I'm licensed. I'm not licensed in Iowa.
Okay.
I have been in the past.
Okay, so you're currently licensed to practice in Illinois and not currently licensed to practice in Iowa, is that right?
Correct.
Okay, and when were you licensed in Illinois?
1993.
Okay, and what about, do you recall the dates that you were licensed in Iowa?
1997 to 2010.
And can you describe your educational background for me?
I went to Augustana, magna cum laude in Phi Beta Kappa, majored in math and religion, Danforth Fellow, all that kind of thing. Then went to University of Chicago's Divinity School, only stayed there for a year. Then came back and worked for John Deere for 11 years, and then went to medical school at Rush in Chicago, and then to residency at Loyola, also right outside of Chicago, where I was the resident of the year my junior year and the research resident of the year my senior year. I was also in medical school the Dayton Bayless Scholar on Humanities at the medical school. Since that time, I've also gone to Gestalt training for 2 years as a Gestalt therapist, and then moved back to the Quad Cities and have been here since 1997.
Okay, thank you, that's a lot that we'll go through here in a moment. So what are you, do you have a specialization?
Yes, I was board certified in general psychiatry, so for adults and children, back in 1999, and then in 2000, I wish I had brought my own CV, 2003 or so, I got board certified by the American Board of Addiction Medicine.
And what does board certified mean?
It means you go through certain training in person, and then you go through usually an 8-hour test or so.
And does that require, you talked about your residency. Was your residency in psychiatry or addiction medicine or
It
both?
was in psychiatry.
Okay.
In psychiatry.
And how did, it looks like, so in 1999 and then approximately in 2003, or 1999 is when you were board certified in psychiatry, and then in 2003 is when you got the certification in addiction medicine. What led you to that point?
That was always an interest of mine. The reason I chose Loyola for residency was to work under a particular Dr. Walter Doris, who had retired. So then I worked under Amin Dagestani, who were both well-known scholars in the addiction medicine field.
Okay, and what is addiction medicine?
Well, it's really broader than psychiatry because it includes the medical side of the addiction process. So we can take people through withdrawal and detoxify them. That's the difference between just a regular addictionologist and one who has the medicine degree. So all forms of addiction, both the physical and the mental, emotional parts of it is what addiction medicine is about.
And does addiction focus on alcohol addiction and drug addiction, or is there something outside of that?
Those are the main focuses, but in the modern age, we pick up sexual addiction, cyber addiction, we pick up pretty much food.
Okay, so, but back in 2003, you would have been focused more on the chemical side of it, substance abuse.
Yes, I was the medical director of Genesis Mark Unit at that point.
Okay.
Was that for 7 years.
And was that before or after you were board certified in addiction medicine?
It was during that time.
Okay. And you stated that you achieved a couple of awards while you were resident of the year, and then there was another one.
Research Resident of the Year.
Research resident. And what's the difference between, can you explain what those are?
Resident of the Year was just a general award for all areas. The research was where we were actually working with, mine was in PTSD, working on a particular field within psychiatry or addiction medicine, and got the award for that.
And how many, is it difficult to get these awards?
Yes.
Can you explain how difficult?
It's by faculty vote. So you usually put up with several, and then the faculty vote. So at least on Resident of the Year, supposedly I was unanimous. The next one, I'm not sure if I was or not.
Okay. So on both of these, the resident of the year and the research resident, the faculty votes?
Yes.
Okay. And how big is the faculty, or was the faculty when you were there?
40, 30, somewhere in that range.
You also stated that you were a Dayton Baylor scholar?
Bayless.
Bayless.
At Rush, the medical school, they always had a funded position that was for a person who could broach the gap between the humanities and the hardcore sciences.
Okay. And can you, when did you receive that award?
1993.
And what was your work in that, when you were that scholar? What work did you do in that field?
You're talking about the Dayton Bayless one? I taught classes to the medical students on positions in literature, positions who had been poets or other scholars, and taught those classes to the medical students. While I was a medical student.
So this is while you were a student, not while you were already a resident?
Right, I was still a medical student.
Okay. And then you also stated that you were a Gestalt, I believe, therapist?
It's a form of psychology after Freud and Jung, the original founders, developed by Frederick Perls. I don't know if you want me to go into the theory behind it, but it's a form of psychotherapy.
Okay. And when did you do that?
That would have been from 97 until 2000.
Were you ever published?
Only in a group on my PTSD studies during medical school.
Okay. And what did you publish?
It was on the effects of late-term onset of PTSD. So we looked at Vietnam vets who had come back, apparently been successful even, and then 40 or 45, when they reached that age, all of a sudden they had a complete breakdown and were never able to recover. So it was considered delayed onset PTSD.
And then more recently, what specific experiences do you have in dealing with and treating substance abuse, chemical dependency?
As I mentioned, I was the medical director of the Genesis, the Mark Unit Multiple Addictions Recovery Center. I was that for 7 years. Then went out into my own clinic and ran, I believe, the only Medicaid accepting heroin addicts who would go on buprenorphine. I was trained in that as well. It's a substitute for heroin. It gets people off heroin without them being stupefied, as heroin would do. And it curbs craving. Called Suboxone. It's been in the news a lot. Suboxone.
Thank you. And Your Honor, prior to today, Dr. Doyle, have you ever been qualified as an expert in the courts of the state of Iowa or Illinois?
Both.
Okay.
I worked for the state itself for the seriously mentally ill who were criminals. So criminally insane is what they call it in Illinois. I worked with them off and on for 2 years when I moved into semi-retirement.
And when did you move into semi-retirement?
2 years ago.
Are you retired today, or are you still-
Semi-retired. I decided to come back out of it. It's too boring. So had to get back into it.
And approximately how many times have you been qualified as an expert in Iowa?
In Iowa, it would probably be only 3 or 4 times. In Illinois, it'd be at least a dozen, maybe several dozen. I've not kept count.
And prior to today, have you ever been qualified as an expert in any other states besides Iowa or Illinois?
No, ma'am.
Your Honor, I would offer Dr. Doyle as an expert in the field of substance abuse, chemical dependency, alcoholism.
No objection, Your Honor.
Thank you.
Dr. Doyle, we haven't met in person, but we have spoken on the phone, or via text, I guess, to discuss your testimony today. Is that right?
Correct.
And are you being compensated for those calls and your time in court today?
Yes.
Okay. And how much are you being compensated?
I think we agreed at $200 an hour.
Did you review any particular documents or evidence in this case to prepare for your testimony today?
Only in general, I checked the newspaper articles on it and some of the material that you had sent over. I'd looked through some of that and our discussions.
Okay. So I want to move then to your specialty in addiction medicine and alcoholism. Can you explain what happens, or before we move to that, would kind of a basic depiction of the human brain help you or aid you in some way in describing the effects of alcohol on the brain?
It might help. I think I could describe it with words only, and if it's not, you could let me know.
Okay. So can you explain what happens when alcohol is taken into the human body, just in general?
Well, it's a suppressant.
And can you describe what suppressant means?
Your brain has a certain state of activity, and if you are a chemical called GABA, when that is increased, your brain's activity sends messages to the muscles to relax. That's why people will drink to relax. It relaxes the muscles through this GABA mechanism. On the other side, there's an equivalent chemical on the other side called glutamate, which tends to be excitatory. So that's what would get like people who are on cocaine, methamphetamine, those are excitatory. So it'll get those guys even to the point to where they shake because their brain is sending out so many fast and furious chemicals.
Okay. So it's my understanding that this chemical GABA, with respect to how alcohol affects the body, it relaxes, puts somebody in a relaxed state.
Or even in a coma.
It can go that far?
Mm-hmm.
And can you explain what happens to your brain specifically when alcohol is in the body?
It hits every system of the brain. So whereas some of our modern chemicals, let's say Ativan, is only toward the parts that have to do with the, I don't want to get too in, but to the GABA parts of the brain, but it's very specific, whereas alcohol just smashes everything. It's like a sledgehammer to the brain. So every part of the brain is affected.
Okay. And does that include memory?
Most assuredly.
And how does alcohol affect memory?
Of course, all of this is theory, but the main notion is that as we store memories, we have an area that is for short-term memory, and in order to move that into long-term memory, underneath on the bottom side of the brain, there's two little, they look like women's breasts, so they're called the mammillary bodies. To go from short-term memory to longer-term memory, you have to go through that little process of the mammillary bodies. In a wet brain, or Wernicke-Korsakoff syndrome, the neurons in that section are, in fact, they turn from pink to black. So they're burned out. So the person can have no longer-term memories beyond just short-term memory. While the person is really drunk, they reach a point, usually 200 or better. That'd be 0.2. I'm used to speaking, like, instead of at 0.08, I say 80 because it's a different measurement. But at 0.2, most people start having problems with their memory, speech, maybe even walking. But as far as the memory is concerned, the memory body's part is blocked by the alcohol. So you don't go from short-term memory into long-term memory.
Okay, so when alcohol, and is that as soon as you start taking in alcohol, or is this at some?
After you reach a certain point.
Okay. And are there stages of kind of alcohol intoxication within a human body that each body goes through?
Yes, we've, in general, for driving, so it's time that they look at physical impairment, they look at 0.08. It was originally 0.1. If some of you older people remember, it was 0.1. They moved it down to 0.08 because they found that there was, in that small amount, there were several people that still were impaired. Many people were impaired from 0.08 to 0.1. Then the next stage, most people go around 200, slurring their words, staggering with some people, some not. 300, the average person would really be sick and probably have to go to the hospital. Children would die. 400, most regular drinkers would die at 400, alcohol poisoning. Typical, and then above that 500, most normals would not survive it. Alcoholics, however, can get such a well-established tolerance that even at high doses, they function, even though they may not be remembering, but they are functioning day to day. And I've had some that, when I was working at the MARC unit, that came in at almost 500, and they didn't appear drunk till they were down to 300. So I don't know if I make myself clear or not, but 300 seems to be the stopping over point where you're getting into serious issues.
And that's for the non-alcoholic, is that right, or the alcoholic as well?
For the alcoholic, as he's coming down, that seems to be the place where their withdrawal really becomes prominent. Whereas a normal person wouldn't have withdrawal really of any significance. But for the normal person, 300 would be a great impairment.
And when a person is intoxicated, what are the short-term effects of the alcohol on the body?
Since it's hitting all those GABA receptors that are throughout the brain and the body, everything relaxes. So it can get to the point where, I think a common phrase is limber-legged. So a person's kind of staggering and not getting around well. They have ataxia. Sometimes they'll have problems with their eyes. Of course, mouth, so they'll start slurring their words or being unable to speak. I don't know if that's sufficient or not, is it?
Could you explain what you mentioned a word ataxia? What is that?
That means not being able, impaired gait, impaired walking.
Okay. So would that be described kind of like as balance problems?
Yes, yes, ma'am.
And if you know I assume you know, like, some of the field sobriety tests that police officers take people through. Is that right? Yes?
Yes, I've been through that training for that myself.
So in some of those, and one of those, they have the person try to walk in a straight line. And so an alcoholic wouldn't be able to do that, is that right? Or not an alcoholic, an intoxicated person would not be able to do that, is that right?
Probably not unless they are a chronic alcoholic and have a tolerance so that they could still be at 200 and walk a straight line.
Okay. And there's also like a one-leg stand test, so you stand on one leg to try and balance. Would that also affect the balance at that point?
Most assuredly.
Okay. And then you mentioned eyes, that there's an issue with the eyes. Can you describe what happens with the eyes?
The phrase that's used is visual ataxia, so it's like problems with your eyes being able to stay steady. So you might roll your eyes around, or with some drugs it'll actually make them shake. Called nystagmus, Nystagmus.
Okay. And this nystagmus, does that cause some of the difficulty with a person being able to balance because their eyes are bouncing back and forth?
It can be, but again, that would be a later, it's the gait, the walking ataxia that comes well before you have visual ataxia.
And by well before, how much well before?
Only in terms of, you would probably be staggering at 200 to 300. You wouldn't get the eye nystagmus until probably into the 400s for the typical person.
Okay. And that's not for the alcoholic, that's for just a general lay person, is that right?
Correct.
Or I shouldn't say lay person, but person that doesn't have the alcohol dependence. And does the slurring, when does the slurring of speech come?
At about 200. For the non-alcoholic.
For the non-alcoholic. And then for the alcoholic, when do these things occur?
It would be hard to say because it depends on how long and how much they've been drinking. For example, I mentioned earlier about 300 being when many of the alcoholics would, not until they were down to 300 did they start showing withdrawal symptoms, even though their blood alcohol is still 300. Okay? So their tolerance is so high that at 300 they may run a company.
And in your experience, so they can still, there's a term called functional alcoholics.
Correct.
Right? And can you describe what that means?
Well, it means that the person is still able to function their regular activities of daily living and day-to-day life at a fairly normal level, even though they're drinking a lot. They don't tend to go through withdrawals as bad because they can drink the next morning. The hair of the dog that bit you, so you get up in the morning and start drinking, and that will usually kick the person out of withdrawal.
And so an alcoholic then, or somebody with alcohol, a dependency on alcohol, or who has formed that, are you able to, other than maybe the smell of alcohol on them, are you able to notice that because they're functional?
You might not. Typical trick is halls. So they'll use halls or cough drops to kind of cover that smell that people might pick up. So.
Okay, so some people that are alcoholics have picked up on the smell and trying to keep that out of their breath?
Mm-hmm.
Okay, is that a yes?
Yes.
What are the long-term effects of alcohol on the brain and on the body?
As I mentioned earlier, the wet brain syndrome, that's Wernicke-Korsakoff syndrome, and what that does is completely burn out the mammillary bodies, that are the part of the memory circuits of the brain. But beyond that, they can have long-term problems with their gait, their walk. So a typical alcoholic has to have a wider base to their gait. Otherwise, if they bring their feet in, they can't keep their balance. So balance issues, really every organ of the body could go. You can get, of course, liver issues, kidney issues, heart issues, muscle, so you can get really just kind of, unlike a muscle, more like you'd think of as something that had been dried meat. Their muscles would just start atrophying. Skin can have problems, have blotchy skin, have all sorts of blood issues. So long-term effects are devastating, leading to death in some people. And then there's also communicable diseases that people get while they're drunk. So that also enters into long-term outlook.
And when do you start to see some of these long-term effects happening in a person that has alcohol
It
dependence?
could vary greatly. I don't think you'd see it probably before a year, but even within a year, you can have a person who's done so much heavy drinking on a fairly fresh brain that just kind of puts it over the edge at a very quick time. Usually, though, you're looking at more like 15, 20, 30 years into that kind of length of time.
And does it differentiate between is there a difference between men and women who drink or alcoholics? Or?
Yes, there is.
And when does it affect men or women more, or can you describe it?
Women more. And it seems to more after they've gone through menopause. Now, I don't know exactly all the science. I got theories, but I don't know the science. But after menopause, it seems that some of the estrogen protection, maybe it's just because she's a mother or whatever else, but after menopause tends to very rapidly lead a woman actually to death. The reasons for that is because women have shorter bowels to have the alcohol transfer through, so more gets put into the system. And also their ability to process the alcohol is slower, so it just keeps recirculating in the woman.
Okay. And
I've had more women after menopause die from alcoholism than I have men. So it's really devastating for a woman if she continues to drink into older age.
okay. And so if you have two people that are relatively the same age and are drinking about the same amounts, one's a man and one's a woman, how these long-term effects that you talked about that affect the kidney, the liver, the
Heart, brain, muscles,
heart, and
blood
those kind
system.
of things, what kind of time frame are we looking at? Let's say the person's in their 30s, or the people.
I've had patients in their 30s who had this complete Wernicke-Korsakoff syndrome. So every day I would have to reintroduce myself to the patient if they were in the hospital. Every day they wouldn't remember from day to day what my name was. Wouldn't remember their own children's names if they had occurred after the Wernicke-Korsakoff had set in. So I've had them as early as 30, and I've had many up into the 60s.
And with respects to somebody that's got alcoholism, do you see them able to control their drinking?
No, that's part of the definition of alcoholism, is that they can't control it. They continue to drink even though there's negative consequences. They start out to drink, I'm only going to have this much. And it's always more than that, or almost all. And if it's not tonight more than that, then tomorrow night will be a real bender that they put on. So there's very little control, or virtually none, in many alcoholics.
And so if an alcoholic isn't drinking today and and puts alcohol in his body, does that start that process all over?
Seems to trigger it, yes.
Okay, so let's say somebody's been sober and not drinking for a year, and then they start drinking again, what happens?
Well, again, depending on their age, many of the physical problems, have been corrected. So a person, since the liver is one of the organs, it's a calyx organ, K-A-L-Y-X, calyx organ, so it can reproduce itself. So that's why a mother can donate a quarter of her kidney to her child, of her liver to her child, and the child then end up growing up to have normal liver functions. so it can reproduce itself. Once it goes past a certain point, it becomes so scarred from so many assaults of the alcohol, trying to process all the poison through the liver, that it reaches a point where it becomes cirrhotic and cannot be regenerate itself.
And
Did I answer your question? I think I got caught up in my, did I answer your question?
So, I'm gonna ask you another question. So you talked about cirrhosis or
Yes.
cirrhotic. Is that cirrhosis of the liver?
Yes.
Okay. And with respect to that cirrhosis, that's something that happens later in the process?
Typically, yes.
Okay. So with respect to somebody, let's say somebody's stopped drinking, they're an alcoholic, they've stopped drinking for a year, and then something happens, and they pick up a drink, right? What happens to their body is it the moment that they pick up the drink, what happens at that moment? Do they have control?
If they're, depending on where they stopped the drinking and got that year, they may be able to heal it and come back to normal function. If they've gone beyond that point, then there will be lifelong issues. Even for the person who has been sober a year, and in that person, since your brain, we know how to tie our shoes because our mothers taught us when we were 4 or 5. Brain cells are as old as you are. In fact, our oldest brain cells go back to probably somewhere in the 7th or 6th month of the pregnancy. Otherwise, they're paired off, they're cut off, and specialize in various areas. If the person has gone beyond a certain point with their, as I mentioned, like the mammillary bodies, it doesn't recover. If you go beyond a certain point with your liver, it becomes cirrhotic, and you will probably have to have a liver transplant if you can avoid drinking, and they'll allow you to get on the list. Did I answer your question again?
Yes.
All right.
With respect to a person's liver, if somebody's already starting to see problems, having a doctor tell them that they have problems with the liver, is that something that can be recovered at that point, or it's something that's already beyond that point?
If they've stopped before it's become cirrhotic, which I think is around 30% of your liver is still functioning, so if you go lower than that, then it's unlikely that you're going to be able to pull the liver back out of it.
And the only option then would be the transplant, is that right?
Correct.
What kind of psychological effects do you see on somebody that's got alcoholism?
Well, typically they already had psychological effects before they went into alcoholism. It is almost a form of self-medication, though I don't subscribe completely to that theory as the origins of alcoholism being self-medication. But it does at one point, the only way that you can stay normal is to continue to drink.
And do you see some things like mental health conditions starting to happen because of the alcoholism, such that it would affect maybe as well as sleep or other things?
Yes.
And can you describe a little bit about that, what mental health conditions typically are induced by alcoholism?
Well, since it's a disinhibitor, so it takes away your inhibitions, the old phrase is in vino veritas, so in wine the truth. Not necessarily the case, but things will come out that you have suppressed because you are now disinhibited, and it can come back in, different rates toward parents or others that you might have brought into your alcoholism. Typically, I am of the position that it's basically genetic disease. At least 75% seem to come from alcoholic clans, even if they aren't raised among the alcoholic clan. So going into alcoholism, in some ways you're set up for some issues.
And does alcohol affect sleep?
Oh, greatly, greatly. So typically, the person says, I drink a few drinks or a few shots before I go to bed to sleep. Within 46 hours, that person is usually waking back up and has to take some more shots if they want to get the full 8 hours. So it disrupts sleep that way, does not allow you to go in certain stages of sleep, chaotic sleep, nightmares. Those sorts of things can frequently happen with a person who's an alcoholic.
And could you see somebody not being able to sleep that's an alcoholic, like having kind of insomnia?
Yes. Or they take a few shots and they'll sleep for an hour or two and then wake back up. So as far as long, restful sleep, typical alcoholic doesn't have that.
And with respect, do you ever see, with respect to psychology, some kind of impulse control problems
Yes.
with an alcoholic?
Yes.
Can you describe that?
Well, frequently be the person who's rageful, starts a bar fight, aggressive, those sorts of things, breaking furniture.
What about emotions and personality? Can you see change in that as well?
Yes, you can.
And
The
can-
whole Dr. Jekyll and Mr. Hyde, that's a typical phrase among the AAers, that they are basically Dr. Jekyll and Mr. Hyde. When they're not drinking, they're Dr. Good Person. When they are drinking, they turn into a creature.
And creature meaning something that's not similar to Dr. Hyde, or the doctor, the good
Dr.
person?
Jekyll. Yeah, oftentimes it's the opposite. So a mild-mannered person becomes quite aggressive. Sometimes it will be the opposite.
And is it always that way? Is it, or can there be times where an alcoholic may seem normal within the drinking and then something happens?
I'm not sure I understand your question.
So do you, with respect to this kind of Dr. Jekyll and Mr. Hyde, is it something that happens like one time, or is it always, or is it somewhere in between that?
It'd be in between that, but if the person is truly alcoholic, repeaters repeat is the presidency. So sometimes a person, let's say they've lost their car. The only way that they can find their car is to get drunk again. So they get into that state-dependent learning. So whatever state they're in, if they learn that, that's the state they got to get back into to be able to remember what they were doing, or to retain what they've learned.
Okay, so with respect to an alcoholic, they would have to, if they've forgotten where their car or their keys are, they would have to get drunk again in order to find the car?
They might,
Okay,
or they may never find the car. I don't want to anybody who may be a drinker think if they've lost something that they should go drink to find it.
okay, so that's just one of the theories or one of the things that some alcoholics are able to do, is that right?
Correct.
Okay. And
Let me, if I might, so let's say a person is aggressive when they're drunk, and that they've established that over time, yes, almost in every time that they would get intoxicated to that level, they would get aggressive. So that's what I meant earlier about repeaters repeat. So the DUI guy who's never driving again gets his keys or beats his wife up to get the keys to go drive. That may be a pattern that he'd never do when he's sober.
okay, so this whole idea of Dr. Jekyll and Mr. Hyde comes from when a person is sober, they, like you said, they would never maybe go get the keys. No, if they were sober, they would put the keys away, knowing that they're going to drink. Is that right?
Yes, they would need the wife or some other person to hold their keys for them.
But the moment that they start drinking and get intoxicated, then that changes. Is that right?
Once they reach that level,
Okay. And so at that point, they've lost control of their what they're doing. Is that right?
yes. most of us would think that for the alcoholic, even one is too many. In fact, the phrase is, one is too many and 1,000 is never enough.
Okay, and what does that mean?
That means that if they have even one, they're probably going to set off things that make it where they drink until they can't drink anymore. Something has to stop them. Okay. And 1,000 never enough is that there's, I'm only going to have 4. Next thing you know, they've done 40.
Is there an idea, do we know when a person develops a tolerance to alcohol?
Be different from person to person. A lot having to do with genetics.
Okay, and also from men to women, it's different?
From men to women, body size. So there's lots of factors that have to do with it. So you see guys who are heavy drinkers, case a day of beer, and would not qualify for any of the typical questions that we used to establish that someone is an alcoholic. They wouldn't qualify for any of those, even though they're drinking that much a day.
Okay, and when you say these questions to establish alcohol, or if they're an alcoholic, you have a set kind of questions that you...
There's many of them.
Okay, and so if somebody is drinking a case a day, that may not qualify them as an alcoholic, but however, they are actually an alcoholic, is that
Well, I
right?
don't know that they would be. Again, if they don't have loss of control, if they're not doing things that are outside of their character, and then various other things have to do with the definition of alcoholism, they may not be doing any of those things. So a typical test is called the cage. And the first question is, have you ever tried to cut down? The non-alcoholic will say no, because there was no reason for them to ever cut down. The alcoholic may or may not say, depending on if they're telling the truth, but most alcoholics have tried to cut down at some point because they know the consequences are coming. And the next one, have you ever gotten angry or upset at somebody who confronted you about your alcoholism? Again, most non-alcoholics would never be confronted, and if they were, it would be patently untrue. The next one is, do you feel guilty about things you do while you're drinking? Typical alcoholic, if he's being truthful, will say yes, he does. He feels really terrible, but he doesn't know how to fix it, or only way he knows to fix it is go get drunk again. And the last one is, if you have ever had a person who got up in the morning to have the proverbial eye opener. So in the morning, you're shaking, you gotta have something that's the eye opener that you wake up to. If any 2 of those are, that I've mentioned, out of the cage, C-A-G-E, any 2 of those are, you got about a 90% chance that you probably are drinking alcoholically.
Okay, so, and I think you described it, that CAGE is just the letters.
Cut down,
an acronym
angry,
that helps
guilt,
you.
eye opener. I'm sorry.
Cut down.
Angry, guilt, eye opener.
Okay. And I think we've talked about alcoholic seizures, but I want to kind of get into these, kind of this withdrawal or the seizure. When does that happen?
It varies. Typically, it happens on the 2nd or 3rd day, but I've had people have seizures when I was director at the Market Unit on the 6th day after they've stopped drinking, even that far out. The older nurses tend to say it was vodka related. I'm not so sure if that's true or not, but they'd always put up a red flag if someone came in alcohol vodka dependent.
So there's a difference between even the amount, or not the amount, the sort of alcohol that you're drinking, or the kind of alcohol that you're drinking?
Depending on its content, yes, and how high it can make your blood alcohol level.
Okay. So is vodka more potent to the body?
As I say, I'm not so sure if that, but the older nurses, when I ran the Mark unit, they always put out a sign that this person was vodka dependent because they extended the time that they looked for seizures.
Okay. And seizures indicate withdrawal, is that right?
Correct.
Can people die from those?
Yes.
And then there's another term that usually goes along with alcoholism that we haven't talked about, and that's blackout.
Blackouts, yes.
Can you describe what that is?
Well, in layman's terms, it's like automatic pilot. You're still functioning. Other people may think that you are not intoxicated. You may appear that way, but you are actually not recording anything through that mammillary body part that I mentioned, brain part that I mentioned earlier.
So can an alcoholic experience a blackout, or how long do these blackouts last? Let me go there first.
That would be very dependent on each individual. It may just be little as, I don't remember going by Ted's house, but it's only that half an hour at Ted's house that you don't remember. But it could be whole weekends. I mean there's that famous movie, Ray Milland on Lost Weekend.
And during the time that an alcoholic, say, is in a blackout, is he still functioning
Yes.
completely like a human being?
Yes, I hear a story often that, Doc, they'd give me the keys to drive and I was in complete blackout when I was doing it. Because the others were staggering that and he wasn't staggering yet. He had such a high tolerance. But he was still in a blackout, not recording.
Okay. And blackout means they're not recording on those,
Through the mammillary bodies to move it from short-term to long-term memory. Right.
and is a person able to recall that ever? That blacked out memory or that blacked out time?
They might come back to like snippets, like just a flash, just like somebody's taking a snapshot of a photograph, not a video. Occasionally you might have a little short video that they'll recall of that night, but then the grander night, no, they do not remember, and it probably will not be retainable because they have burned out the pathway to make it a long-term memory. It just isn't there.
Okay. And when they have these snippets or kind of flashes of their memory in this blackout, do they try to make sense of that?
Typically, and very serious alcoholics will, in fact, fill in the time that they've forgotten. It's called confabulation. Brain doesn't like gaps, so their brain will start filling in the gaps with memories that they actually kind of make up. Confabulation, they fabulate the memories.
And so if somebody is in a blackout, they might make up what happened, even though it's not the truth. Is that right?
Correct. But they would believe it was the truth. That's, confabulation means they actually believe it is the truth. Their brain has filled in that gap.
And the alcoholic themselves believes it, and then the people that are listening to it would actually believe it as well. Is that right?
They might.
Okay. Unless it's maybe a wife or somebody that's been around for a while, right?
And knows, yes.
Okay. When alcoholics, I think you kind of talked about this a little bit, but when we were talking about blackouts, that with respect to an alcoholic that's in a blackout, and the person is given the keys to the car because they, the other people aren't, believe they're more functional or able to drive than the other ones, could these others even believe that they were kind of lucid or almost more sober?
I got lost in your pronouns. So
Sorry.
Who are we talking about?
So, if we have a person that's in a blackout, an alcoholic in a blackout, could others believe that that person is lucid?
Yes, that's why they give him the keys. He seems the least intoxicated, seems the least impaired, though in fact he's in a blackout and might have a very high blood alcohol level, higher than his others who are feeling the effects and are staggering and don't think they can drive.
And I just want to get into one kind of more topic, and that's that we've talked a little bit about, and that's these points. 3, if somebody's an alcoholic in a 0.3 or a 300, as you would say it, what would you expect to see from that person?
Maybe nothing. I've had people that were high up in different companies in the area and they functioned perfectly well, and as I say, they're functioning at 300. And maybe at the last drunk they got up to 450 or 500 It's not until they get down to 300 that they start feeling the withdrawal. Like we would if we went from 200 down to 0, we'd feel the withdrawal at 100. They're going from 500, let's say, down to 300, and then they start feeling the withdrawal. But otherwise, they're functioning quite well.
Thank you, Your Doctor. I have no further questions, Your Honor.
Mr. Jones?
Thank you, Your Honor. Good morning, Doctor.
Good morning.
You were just discussing the idea of confabulation, that a serious alcoholic who is a blackout state, their brain may try to fill in the gaps and they end up with false memories. Is that right?
Correct. In some, I don't want to, that's not like a blanket statement for all, but in some alcoholics, yes.
So it can happen to some alcoholics?
Yes,
Can you also have alcoholics in a blackout state where they have those snippets and flashes of memory you mentioned, where those snippets and flashes are actual memories,
yes,
not made up?
not made up.
Okay. Nothing further, Your Honor.
Nothing
Anyway.
further.
You may step down.
Thank you.
We're going to take a break at this time. I know it's a little bit earlier, but we're going to take a break. So ladies and gentlemen, please, I'm reminding you of your admonition. Please do not discuss this case amongst yourselves. Please continue to keep an open and attentive mind. We'll be in adjournment for about 10, 15 minutes. Thank you.
All rise for the jury.
You may be seated. The defense may call its next witness.
Thank you, Your Honor. The defense calls Christopher Behal.
Do you swear to tell the truth, the whole truth, nothing but the truth?
I do.
Please have a seat there. You may proceed, Mr. Prentice.
Thank you, Your Honor. Mr. Behal, just, I guess to make the record complete, please state your name and spell it for the record.
Christopher Behal, Christopher Behal.
And how old are you, Mr. Behal?
31.
Where are you from?
Davenport, Iowa.
Born and raised?
Born, raised in Durant for most of it.
Okay. You go to Durant High School, for example?
I did.
Okay. And what brought you back ultimately to the Davenport area?
We moved right before the end of my senior year, and that's where I've been since until I moved to Eldridge.
Okay. And when you say we, I presume that's you and your parents?
Yes, that's correct.
Okay. What did you do for work?
Mainly manufacturing.
Okay. Is there any specific training that you, that was required, I guess, for that particular position?
CNC training.
And what is that?
Basically running brake presses or lasers and then fork trucks as well.
Okay. Is that, like classroom work or is that on the job training?
Mainly on the job training, yeah.
You know an individual by the name of Taylor Escontrias, is that correct?
I do.
And how do you know Taylor?
She was my girlfriend, and we met at Country Oaks, which is a rehab facility.
What year, if you can recall, did you meet Taylor?
2023 or 2022, one of those.
Okay. And you mentioned Country Oaks. Is there like another name or moniker that it goes by?
Not that I'm aware of,
Okay.
other than just Oaks, but
Okay. Is it associated with CADS? Are you familiar with that?
I believe it's partially associated with CADS. I don't know if it's completely like a co-op unit or how that works.
Okay. Now, this is detox, rehab, or both?
It's no longer detox, it's just rehab. It was in the past a detox and rehab facility.
Is it residential?
Yes.
Okay. Can you just kind of explain, when you get rehabilitation there, what does that look like? Like, what's the process?
Now, when you get rehabilitated there, you get you get on board there. You go in, you get signed on, and then you start off with a 21-day course, I believe is what they are right now. And you sit through classes every day. I don't know, I want to say 8 to 10 hours a day for 21 days until you complete that course, and then you can stay on for a extended period of time in their halfway house. And I think you can stay up to 90 days extra in the halfway house program while you're still doing classes and getting interviews for jobs and trying to get rehabilitated back into society.
Okay. And is that, at least that second half that you referenced, that halfway house portion, is that voluntary or is that like a requirement for the program?
It is voluntary, yes.
So in essence, if you think you need that extra help, you can ask to be in the halfway house?
Yes.
Okay. And was that the first time you'd ever sought rehabilitation for alcoholism?
No, it is not.
And I guess I should ask you that. Were you receiving it for alcohol or for drugs or for something else?
I was receiving it for alcohol.
And how many times did you try to complete that or any program with respect to rehab?
It would have been that would have been my second time at Country Oaks, and I had also gone to outpatient, I believe, 2 other times.
Okay, so you had 4 attempts at rehabilitation for alcoholism, is that correct?
That is
Okay, and if I understand you correctly, 2 of those were in an outpatient capacity,
they were
and then 2 of them were residential.
correct.
In what order, if you can recall, were they?
Want to say inpatient or residential at Oaks, and then outpatient at Rosecrans, and then inpatient again at Country Oaks, and then outpatient at Cats.
And why the variance? Like, why outpatient versus inpatient for you?
Part of it was because of jobs at the time, so I could still keep working and do rehab at the same time.
Can you work while you're receiving inpatient treatment or inpatient rehab at Country Oaks or a facility of that type?
Not that I'm aware of.
Okay.
Your job can be put on hold, but you're not, unless you're in the halfway house program, you're not able to work and continue your rehab.
So maybe a silly question, but I think a necessary one. Why were you seeking rehabilitation at all?
Because my alcohol dependency had basically thrown my life into an unmanageable mess.
I think that's fairly specific, but can you give any more detail about the ways in which alcohol has affected or impaired your life?
I have 2 DUIs. I've lost multiple jobs, the same job multiple times. I've lost friends, I've lost respect, I've lost family, I've lost a lot because of my alcohol issues.
Now, I understand based on, I think, an interview that you had that was presented to this jury already, that you have some other conditions that you receive medication for. Is that correct?
Correct.
Some of those are physical, some of those are mental or intellectual. What are the medications you take for mental health?
I take sertraline for anxiety and depression.
Can you spell that if you know?
Sertralin, I believe.
I think there's an E in there for purposes of the record, but you are correct. And what is that medication for?
Anxiety and depression.
Okay. Any other mental health diagnoses that you have?
No.
Okay. Obviously, you've expressed already what alcohol has done, how it affected you. How did it make you feel about yourself?
Worthless. I mean, basically, that's the gist of it, because I mean, that's what it did to my life, is made it worthless, because all I did was losing jobs and respect and everything that made my life.
Now, what was your drink of choice?
Vodka.
Were you the type of drinker that would drink anything that was on hand, or was it always and only vodka?
It was anything on hand.
Okay. But it sounds like if you had a choice, you would be purchasing vodka, or at least get access to it. Is that correct?
That's correct.
Would you monitor in any way your alcohol intake? For example, would you cut yourself off at a certain point, or would you drink till the bottle is empty?
Most of the time it would be drinking till the bottle's empty. I had multiple times tried just drink, just this much, this little amount, this bottle, and not anymore. That rarely happened. That rarely was effective, though.
Now, when, if you can recall, did your drinking, what age were you, I guess, when it started to really significantly affect your life?
I would say around the age of 23 and 24.
So I'm doing the math right, about 6 or 7 years ago?
Yeah.
And did it kind of happen all at once, or did it just kind of gradually happen?
It gradually happened. At first, it wasn't really a problem. You know, it was just casual drinking with friends or by myself. It wasn't really by myself at that time. I mean, it gradually became just by myself, but it was just fun, lighthearted drinking, and then it became something where it was kind of necessary, more or less, to function on a day-to-day basis.
Are you familiar with the term withdrawal?
Yes.
Did you ever experience a withdrawal?
Yes.
How, if at all, would it impact you? Like, what symptoms would you have?
Incessant vomiting, lack of sleep. Sometimes I would go days without being able to sleep. I would be shaky. I would be unable to move very steadily for a day or two after. Grogginess, unable to eat, unable to drink fluids without throwing up almost immediately. And then seizures. I started developing seizures about 2018, so 7 years ago.
Were you ever given an understanding for why all of a sudden you were seizing as it related to a withdrawal symptom?
I was never given a clinical diagnosis. I had a couple of doctors say that they thought it was because of withdrawal, but I had never actually had a concrete, this is this reason. I had gone to a neurologist that basically told me he had no idea.
But you were never prescribed medication for seizures, is that right?
I believe I was prescribed it within the last 2 months before, or last month before, March 2024. But I wasn't able to fulfill it because I didn't have the funds to buy the prescription.
Okay, so you received the script, but you never filled the script?
Correct.
Okay, so you never took the medication?
No.
Now, how long after sort of your last drop, the bottle's now empty, would it take you to start being symptomatic?
For withdrawals?
Yes, sir.
Usually, after the last drop, it would usually be the next day. Usually waking up the next day, and then it would start to where, the next couple days I wasn't able to sleep. I wasn't able to keep water down, and if I was, it was in very small quantities. Acid reflux was, skyrocketed because I wasn't taking my medications during the time. And I wasn't able to keep anything down because I was vomiting all the time. So, it started the next day.
And I apologize, I'm gonna ask you a question that's incredibly out of order, but are you right or left-handed?
I am right-handed.
Now I want to circle back to Country Oaks. Is that a unisex program? Are both sexes accepted? How does that work? Like, is it men's only or women's only, et cetera?
It is a unisex program.
Okay. But somehow I understand you came to know Taylor. Can you explain how that is in a unisex program?
Basically, it offers help with rehab for men and women for alcohol, drugs, or I think it's just alcohol and drugs dependencies. And so you're all in a classroom every day. Whoever's in the START program, you're seated in a classroom around males and females, and then your sleeping areas are separated, but so you sleep with the males and females sleep with the females.
When you're not in class or receiving treatment, is there like common areas or areas in which you can just kind of chat and familiarize yourselves with each other?
Yes, there's an area where we have classes that's free range for after classes are done and in our free time. There's a pool table downstairs along with a movie room, and then there's the outdoor smoking area along with basketball court, and you can just, walk that little drag that they have out there that they allow you to keep within those confines.
Okay. And I understand that you and Taylor sort of hit it off. Is that fair to say?
Yeah, I mean, not at first, because I'm generally shy when it comes to new people, but we started talking, and then, I found excuses to help her out with cleaning up after lunch and cleaning up in the kitchen in the eating area, which is the same as our teaching area. And then outside smoking cigarettes, we just became associated with each other on a regular basis.
Okay. Was it friendly at this point, or was it romantic, or how would you have described your relationship at that point?
We were just friendly at first. It didn't really get into romantically until after the START program was done, and we both got into halfway together. And then we started texting each other. She would text me on my way to work and while I was at work, and we started texting every day. And then one day she kind of texted me and was like, I've been thinking about you a lot lately, and then it just kind of went from there.
Now, you use the word text, and sometimes that term is conflated. Would you actually communicate through conventional texting, or would it be through a messenger app or something else?
It would be through either text messages, Facebook, or Snapchat.
I take it you both had phones at that time?
We did.
And approximately how long, if you know, after you two met, did the relationship turn romantic?
Maybe a month and a half, 2 months after we met.
And what were the living arrangements at that point?
We had no determined living relationships. I remember asking her at one point if she had anywhere to go after this. She said no, and a couple days later I offered her, if I got an apartment, if she would like to move in, so she'd have a place to stay. And then progressively, towards the end of it, maybe a couple weeks before the end of it, she decided that she would move in with me, and so we ended up moving in with each other after the program ended.
And which complex, if you will, or apartment did you guys cohabitate?
At first, we lived in 104 Crestview, I believe, in apartment 1, and then we moved over to 105 Crestview in apartment 4.
Why the move? It sounds like it was a short move.
It was just a 1-bedroom at first until a 2-bedroom opened up. So the landlord let us live in that one until the 2-bedroom opened up.
And for the entirety of your relationship, was it a consistent boyfriend-girlfriend style relationship, or were you guys kind of on and off?
It was consistent.
Was it serious enough that either one of you met the other's family?
Yes, I met her mother and her stepfather, and she met the majority of my family.
Um, Now, I want to talk about March 13th, 2024, okay?
Okay.
Now, at this point, had you two resumed drinking again?
On March 13th?
Yeah, in other words, since you left the rehab facility together, did you stave off alcohol?
No, we started drinking the day after we left rehab.
So as of March 13th, 2024, you guys were back on the bottle?
Yes.
I want to just kind of go through that day to the best of your recollection. So I want to start with roughly when you woke up. Do you have any idea when you woke up that morning?
I would say around 7 o'clock, 6 o'clock in the morning.
Okay. And did you both wake up at about the same time, or did you guys wake up at different times?
I believe she woke up before me.
Did you guys share a bedroom?
Yes,
Okay. So you were in the same bed, correct?
correct.
When you got up, did you two formulate sort of a plan for the day, what you intended to do?
Yeah, our plan for that day was to go and donate plasma in Davenport.
Okay. And there's been some testimony about it, but I always forget the letters that start off that plasma place. What is it called?
CSL plasma?
Okay. And that's located downtown Davenport, is that right?
Yes,
Just a few blocks from here.
correct.
All right. And who drove, if you recall?
I drove.
Okay. Kind of speaks for itself, but what's the purpose of donating plasma?
The purpose for donating plasma was to gain extra money.
And did you make it to the plasma location?
We did.
Okay. Were you able to donate?
I was not.
Why not?
My blood pressure was too high.
Was Taylor able to donate?
Yes,
And did she do so?
yes.
Approximately how long does that take?
About an hour.
Do they check things like blood alcohol level or anything? Like, what are the things that they check to make sure that you're available to donate?
They check your blood pressure, your weight, your plasma percentage. I don't know exactly what it is, and then your temperature, I believe.
But she passed whatever testing they had and she donated.
I believe she failed the first round, and then she went back for a retest and was able to donate, yes.
Okay. And did you do anything while she was donating?
I just sat out in the lobby on my phone until she was done.
Okay. And once you two left the plasma location, what'd you do?
We went to Aldi.
Okay. Remember what you purchased?
The only thing I remember was chocolate chip cookies.
Okay. And after Aldi, where'd you go?
The dollar store.
Okay. What purchases were made there?
Foundation, I believe.
Okay. And after the dollar store?
We went to Hy-Vee.
Just more food, I assume?
Soda.
And after that?
Casey's for vodka and cigarettes.
Now, which Casey's location was it?
The one right around the area of that Hy-Vee and dollar store on that main road in Eldridge.
Okay. So off LeClaire Road, that being the main road in Eldridge?
I believe so, if that's the road, yes.
Okay. So you stopped at Casey's and you purchased vodka, is that what you said?
Vodka and cigarettes, yes.
Okay. Do you know how much vodka you purchased?
A gallon.
And what type of vodka you purchased?
Hawkeye vodka.
And then, any other stops before you made it home?
McDonald's.
Okay. Again, just more food, I assume?
That is correct.
Okay. What time is it now that you are arriving home after these stops?
11-ish, noonish.
Okay. From the moment you woke up till this 11-ish, noonish time period, had you had any alcohol that day?
No.
When you got home, what did you guys do first?
We laid down for a little bit, and then, no, we scratched that. We went and ate lunch, and then we laid down for a little bit, both took a shower, and then we had sex. And then we played cards for a little while, listened to music. We went back to the bedroom, and then we had a cigarette, and then we laid down and talked. I started to turn the TV on, and then I realized that we were talking more, so I turned the TV back off. And we just sat talking about her family and my family, and that's the last thing I remember.
Now, how long after you arrived home with the vodka did you two start drinking?
Right after eating, so 20 minutes, half an hour.
I guess I should ask, is Taylor drinking as well?
She is, yes.
Okay. And is she drinking the same thing you are?
Yes,
And what is that?
Hawkeye vodka.
Again, I know you guys aren't measuring volumes, but how much of that vodka do you recall getting through?
Last time I remember, I would have been over 3/4 gone
Of the gallon that you purchased?
of the gallon, yes.
And that was between 11-ish, noonish that you arrived home and whatever the last thing is you remember.
Yes.
Now, what is the last thing you remember with respect to you and Taylor that night?
The last thing that I remember is laying down to go to bed with her. Or not laying down to go to bed, but laying down in bed talking to her. Is the last thing that I consciously remember doing.
And then after that, what was the next sort of time in which you have a firm recollection of what was taking place?
A firm recollection would be waking up in the hospital.
Thank you. Those are my questions at this time, Your Honor.
Mr. Jones?
Thank you, Your Honor. Good morning, Mr. Behal.
Good morning.
I'm going to cover some of the same ground you just did with Mr. Puentes, with a few extra questions. Just to confirm, as of March 13th and 14th of last year, you lived at 105 Crestview Drive, Apartment 4 in Parkview, Iowa,
Correct.
and Taylor Escontrias lived with you.
Correct.
The two of you shared a bedroom,
Correct.
you shared a bed,
Correct.
you're in a romantic relationship with her,
Correct.
and it was a sexual relationship.
Correct.
Did the two of you pool money?
What do you mean?
Well, for example, you went to a number of stores that day, Dollar General or Dollar Store, Hy-Vee, Casey's, etc. Who was paying for the items you purchased?
She was.
And she was purchasing things for both of you.
Correct.
Okay.
other than the foundation.
I think during your interview with Detective Rowling, you told him that there were some problems in your relationship with Taylor.
Correct?
You told him that Taylor always kind of made it seem like you weren't part of the relationship.
Correct?
And Taylor told you earlier on March 13th that it was a one-sided relationship.
Correct?
And you told Detective Rowling that Taylor was always talking shit
Correct?
and that it made you feel like shit,
Correct?
but you were trying to work on things with Taylor.
Correct?
I believe you just mentioned that as of March 13th and 14th, both you and Taylor had phones.
Correct?
And if I remember your interview right, that evening on the 13th, while you're playing cards, the two of you were taking turns playing music on Taylor's phone. Is that right?
On both of our phones.
Okay. And you recall Detective Rowling asking you where Taylor's phone was when he spoke with you on March 14th?
Correct?
And you knew where the phone should be?
Should have been by the bed. Correct?
Right. You told him it should have been right next to the bed on Taylor's side.
Correct?
And you knew Taylor's phone did not have a passcode or PIN.
Correct?
You mentioned going to the hospital. I want to talk with you about your injuries. You had a cut on your side,
Correct?
and you told Detective Rowling you had no idea how you got that cut.
Correct?
And you told Detective Rowling, for all you knew, you could have accidentally stabbed yourself.
Correct?
And you told Detective Rowling that you actually thought the cut came from the car accident.
Correct?
Okay? And you received treatment for that cut at the hospital.
Correct?
Okay? You got stitches.
Correct?
You did not have a concussion.
I do not know.
Okay? Your CT scans showed no acute findings when you were at the hospital, didn't it?
I don't know.
Your Honor, may I approach the Elmo?
You may.
I'm going to show you some pages from Defense Exhibit 5, which are your medical records. You read the highlighted portion?
Can I? Yes.
Yeah, it says CT head and C-spine showed no acute findings. Is that right?
That is what it says, yes.
For reference for the record, that's page 115 of 137, which appears at page 136 of the PDF that forms Defense Exhibit 5. You were diagnosed with an abdominal laceration, alcohol intoxication, and hypokalemia.
I would assume so,
Let's
if
take a
that's what
look.
the record said.
Page 111 of 137 appears in your Exhibit 5 at page 132. It says diagnosis, abdominal laceration, alcohol intoxication, and hypokalemia. Is that
Correct?
right? Hypokalemia is a low level of potassium. Is that correct?
I am not sure.
Let's take a look at your discharge instructions. Page 130 of 137, which appears at page 151 of the PDF in Exhibit 5. Highlighted portion says hypokalemia is a low level of potassium. Did I get that right?
Correct?
It states this problem has many different causes. Kidney problems, diet, and medicines like diuretics and laxatives can cause it. So can vomiting or diarrhea. In some cases, cancer is the cause. Your doctor may do tests to find the cause of your low potassium levels. Did I get that right?
You did.
Word concussion doesn't appear anywhere in your records in Exhibit 5, does it?
Not that I have been shown, no.
Just to be clear, Your Honor, when I've referenced Exhibit 5, the defense did not use a letter label for that exhibit. It's marked as Defense Exhibit 5. Let's turn to your interview. Detective Rowling, at the start of it, asked you about your intoxication level,
I believe so.
and you told him you were feeling pretty lucid.
That is what was said, yes.
That's what you said.
Yes, that is what is said, yes. I apologize.
And on March 14th, you were coming off of a pretty long bender.
Yes,
You told Detective Rowling that you're a heavy drinker.
correct,
You told him you drink a lot,
correct,
that you're an alcoholic.
correct,
And you had been on a bender for about a week, then off for 2 to 3 days, and then you drank again on March 13th.
correct,
And it's normal for you when coming off a bender like that to not sleep for the next 3 or 4 days.
correct,
Detective Rowling spoke with you about what happened at your apartment the evening of March 13th to the 14th, and you gave Detective Rowling 2 different versions of what happened.
correct,
The first version, you said you remembered Taylor getting a knife, you tried to take it away from her, she sliced you or slashed you with it, and you shoved her into a wall before getting the baseball bat.
correct,
None of that was true.
no,
You made it up.
correct,
But you did hit Taylor with a baseball bat.
as far as memory goes, yes,
You told Detective Taylor that you remembered hitting her with a bat.
correct, as far as memory goes, yes,
All right, Your Honor may approach the witness.
You may.
Show you State's Exhibit 23. Recognize this?
I do,
It's your baseball bat.
correct,
This is the bat you hit Taylor with.
correct,
That's your blood on the bat.
correct,
When you hit her with that bat, Taylor was facing away from you.
as far as memory I can construe and, sorry, I apologize, as far as my memory withstands, yes,
You told Detective Rowling that Taylor was facing away from you when you hit her with that bat.
correct,
That she was on the ground, either crawling or kneeling.
that was what was said, correct,
That was what was said by you.
correct,
And Taylor was within 5 feet or so of the front door to your apartment.
correct,
You told Detective Rowling you believe Taylor was crawling toward the door when you hit her with the bat.
correct,
And you told Detective Rowling you didn't know why Taylor was crawling toward the door.
correct,
You thought it was probably to leave or get help or something.
correct,
You told Detective Rowling you remember Taylor screaming.
correct,
Taylor was screaming while she was trying to get to the door.
correct,
And you told Detective Rowling that she stopped screaming when you stopped swinging the bat.
correct,
This is a point I'm not clear on. Did you stop swinging when she stopped screaming, or did she stop screaming after you stopped swinging?
I am unaware,
Did you tell Detective Rowling you couldn't put an actual number on how many times you hit Taylor with a bat?
I believe so,
You thought it was maybe 6 times?
I believe so,
Dr. Klein testified about Taylor's blunt force injuries. You inflicted those.
I would assume so,
You inflicted 15 lacerations to Taylor's head.
according to evidence,
You inflicted 1 abrasion to her head.
according to evidence,
You inflicted 1 contusion to her head.
according to evidence.
You don't dispute that, do you?
I can't dispute the evidence in front of us,
You inflicted 1 abrasion to her back.
according to evidence,
You inflicted 6 contusions to her back.
according to evidence,
And you inflicted another 4 contusions to her upper extremities.
according to evidence.
May I approach the witness, Your Honor?
You may.
Show you Exhibit 29. Recognize this?
I do,
That's your knife, isn't it?
it is,
It's got Taylor's blood on it.
it does,
And after you were done beating Taylor with the bat, Exhibit 23, you stabbed her with Exhibit 29.
I'm going to object argumentative.
It's sustained.
Can we approach?
You may.
All right, Mr. Behal, let me rephrase that. After you hit Taylor with a bat, you stabbed her with a knife that states Exhibit 37?
I believe that was what was said, yes.
Yep. And you told Detective Rowling you remember stabbing Taylor?
Yes,
You stabbed her in the throat
I believe that's what was said, yes.
by you?
Correct.
And you stabbed Taylor in the throat while she was by the front door to your apartment?
I believe that's what was said, yes.
By you?
me, correct.
And you told Detective Rowling you couldn't say why you stabbed her,
Correct.
but you thought maybe it was because Taylor was still moving and you might as well put her out of her misery given how much damage you'd already done to her.
Correct, that was what was said.
By you.
Correct.
You told Detective Rowling that you remembered stabbing Taylor with a knife 2 to 3 times.
Correct.
Do you still remember that as you sit here today?
Do I still remember exactly what? I'm sorry.
Let's break it down. Do you still remember stabbing Taylor that night, March 13th to 14th of 2024?
No.
Taylor had 6 stab wounds to her neck,
According to evidence, yes.
and she had another 7 stab wounds to her torso.
According to evidence, yes.
You don't dispute those?
I cannot dispute the evidence displayed.
All right. And you're the one that caused those stab wounds.
I am unaware.
Do you think someone else did it?
I cannot say for sure, either way.
Is that simply because sitting here today you've forgotten stabbing her with the knife?
No, sir. What was being attested to is that I said to Detective Rawlings that she was stabbed 2 times, 2 to 3 times.
You told him, Detective Rowling, that you're the one who stabbed her 2 to 3 times.
I believe that's what was said, yes.
When you told Detective Rowling that you remembered stabbing Taylor, did you remember stabbing Taylor?
At the time, yes.
Your Honor, may I approach the witness?
You may.
Show you State's Exhibit 25. Do you recognize this?
I do.
Is this your screwdriver?
It is.
It's got Taylor's blood on it.
Yes.
You told Detective Rowling you didn't remember anything about a screwdriver.
Correct.
Do you remember anything about a screwdriver today?
No.
Do you agree that you stabbed Taylor with that screwdriver?
No.
You agree she had 23 stab wounds from that screwdriver?
According to evidence, yes.
She had 9 stab wounds from the screwdriver in her head.
According to evidence, yes.
She had 3 stab wounds from the screwdriver in her neck.
According to evidence, yes.
6 stab wounds from the screwdriver in her torso.
According to evidence, yes.
5 more stab wounds to her right upper extremity.
According to evidence, yes.
And you did that to her.
I cannot say.
If you didn't do it, who did?
I cannot say.
You killed Taylor Escontrias?
I cannot say.
Do you remember talking to Detective Rowling about what you did after you stabbed Taylor in the throat with a knife?
I do.
Yeah. You told him that you debated whether to lie down?
I do.
And as you thought about lying down, you were like, no, then the cops are going to get me.
That was what was said, yes.
By you?
Correct.
And you decided to leave.
I cannot attest to that.
Did you tell Detective Rowling when you were interviewed on March 14th that you decided to leave?
I told him that I assumed that would have been what happened because I had, was found at the crash site in my car. I
Let's
cannot
take-
attest to actually leaving.
Let's take a look at the actual recording.
Okay.
Ladies and gentlemen, at this time, there's a matter I need to take up outside your presence. I would remind you of your admonition. Please do not discuss this case amongst yourselves, and please continue to keep an open and attentive mind. We'll be in adjournment for a brief moment. Thank you.
All rise for the jury.
Let the record reflect we're outside the presence of the jury. The defendant is present along with his counsel and counsel for the state. Mr. Jones, I know you wish to make an offer of proof, but before you do so, I would like to make a record of our previous bench conference and then make a record as to the last bench conference. The first bench conference was as a result of defense counsel's objection as to argumentative. There was a discussion about the question that was asked by the state. The defense made arguments as to the line of questioning. The court, at the time that the objection was made, took it as to the wording of beating rather than hitting. It was based on that the court made that ruling. And as a result, then the state said that they would rephrase. Is that a fair summation, Mr. Jones?
Yes, Your Honor.
And Mr. Puentes?
It is, Your Honor.
Thank you. The next bench conference was concerning the defense's objection to the last question asked by the state. The defense believes that was not an appropriate question as to Mr. Prentice, I'm going to let you make your argument since we're going to have an offer of proof by the state.
I appreciate that, Your Honor. And to be clear, I don't know that I yet have made the objection, but I did ask for the sidebar.
That's true.
This was being queued up to impeach my client, or at least an attempt to impeach my client, based on prior inconsistent statements, presumably, is what was going to be presented. My issue with that primarily is that that is an appropriate mechanism in the event that the defendant denies having made a statement. I think he's been consistent with the line of questioning thus far, either with respect to conceding that that's what the video showed, or indicating that he doesn't have any independent knowledge of it. Neither of those would be appropriate for impeachment because he hasn't denied having made the statement. I think he's almost in effect trying to refresh his recollection, but in a way that I don't think is allowed by the rules. So if he's trying to impeach again, the answer, at least as I recall, that was given by Mr. Behal, would not authorize impeachment at this purpose, at this time, because he had not actually denied having made the statement. That's all, Your Honor.
Mr. Jones?
Thank you, Your Honor. I obviously don't have a real-time transcript in front of me. I believe the question was, did you tell Detective Rowling that you then decided to leave? And then Mr. Behal responded saying, no, it was, I imagine that's what happened, something along those lines. I can't recall if I asked again, but you did tell him that you remembered, I can't recall how it went. The clip I was going to play is the portion of the interview with Detective Rowling that Mr. Behal and I are discussing, where he starts out saying something like he imagines he decided to leave, but by the end of it he says he did decide to leave. I believe that he does not remember taking his keys. I requested an opportunity to make an offer of proof so I can play the clip. Everyone can see what's involved, and the court can determine whether it's proper impeachment in these circumstances. So if Kim could please put me up, hopefully the equipment is going to cooperate.
Staggered like 2 or 3 times around here. What do you remember after that? Debating on if I was gonna leave, and then was like, no, and the cops are gonna get me, and so I guess I must have decided to leave. And that's all I remember is basically deciding to leave. I don't even remember grabbing my keys.
So Your Honor, in the clip just played, the defendant said he remembered deciding to leave, but did not remember where he's getting his keys, which I believe properly impeaches the statement the defendant just made in front of the jury.
One moment, please. After considering the defendant's answer to the question, I do find that it's proper impeachment and will allow the state to do so.
Thank you, Your Honor.
I'll bring the jury.
Is it useful when the jury's back in to read the last question and answer, just to get them back up to speed or not?
That's satisfactory to the state, Your Honor.
I'll ask my court reporter then to read the last question and response, and then you may proceed from that point.
Thank you, Your Honor.
That's right.
I'll just go back to this one.
Thank you, ladies and gentlemen. Based on my rulings, I have been asked to have my court reporter read the last question that was asked by Mr. Jones and then the response by the defendant. After my court reporter has read that to you, then Mr. Jones will proceed.
Question, did you tell Detective Rowling when you were interviewed on March 14th you decided to leave? Answer, I told him that I assumed that would have been what happened because was found at the crash site in my car. I cannot attest to actually leaving.
Thank you, Your Honor. Kim, can you put me up, please? All right, so let's take a look at Exhibit 45. This will be a portion of the interview where the body camera date and time stamp starts at March 14, 2024 at 10:37 and 30 seconds a.m.
Staggered like 2 or 3 times around here. What do you remember after that? Debating on if I was gonna leave, and then was like, no, and the cops are gonna get me, and so I guess I must have decided to leave. And that's all I remember is basically deciding to leave. I don't even remember grabbing my keys.
Mr. Behal, you didn't call 911?
Not that I recall, no.
Didn't try first aid.
Not that I recall.
You left the apartment.
It seems this way.
You left Taylor behind.
Correct?
She was dead or dying at the front door.
I would assume so.
And you left so the cops wouldn't get you.
I would assume so.
No further questions, Your Honor.
Mr. Puentes?
Just briefly, Mr. Behal, we just went at length through your video. Do you remember that?
Yes.
The video is evidence already. You don't contest the video in the condition that it's in, do you?
No, I do not.
Okay. Do you have, however, any actual independent recollection of what took place since your last drink to the time that you woke up in the hospital?
No, I do not.
No further questions.
No recross, Your Honor.
You may step down.
With that, Your Honor, we've exhausted our witnesses and the defense would rest.
All right. Could I see counsel at the bench, please? Ladies and gentlemen, as the defense has rested, there are some matters that I need to take care of in order to prepare this case for closing arguments and reading of the jury instructions. After you left on Friday, we did start some of that preliminary work, but there is still work for us to do in that regard. And so, as I said at the beginning, we're mindful of your time, and so rather than have you sit here and wait on us too much like you have on occasion, we're going to excuse you at this time, and I'm going to ask that you return at 1:50, and hopefully we'll start approximately 2 o'clock then with the remainder of the trial. All right? I would remind you once again of your admonition. Please do not discuss this case amongst yourselves or with anyone else, and please continue to keep an open and attentive mind. Have a good lunch.
All rise for the jury.
the jury come back, and so that we could work on jury instructions and make a formal record on those instructions prior to the closing arguments. I know the state has provided some supplemental instructions. So at this time, what I would like to do with counsel, at least for the time being, if we can have some informal discussion concerning the instructions, and then hopefully come back on the record either at 1:15 or 1:30, and then have everything ready to be prepared for closing arguments at that time. Does that seem fair to the state
Yes, Your Honor.
and defense?
Yes, Your Honor.
All right, thank you. This will conclude the record at this time. Mr. Puentes, any comment on that?
No objection.
So just be adding the word only after concerning in those two instructions.
We'll include that then. And then next,
Last one is the marshalling instruction for domestic abuse assault with intent.
yes.
Right, in element one, the start of the third line, it says placed. The D should not be in there. That's the wrong tense. We're supposed to be showing the defendant did an act which was meant to place Taylor Escontrias in fear of immediate physical contact.
So eliminate the D.
Correct.
Okay.
Other than that, I think the instructions look good.
Mr. Puentes or Mr. Eagle, did you see any typographical matters that need to be addressed?
Typographical, no, Your Honor. I don't know if now is an opportune time to make our record about the intoxication defense instruction, or if we want to address that.
We'll just do that as we number.
Okay,
That's what I would prefer.
very well.
Okay. Let's just make those changes and then we'll make our record. Thanks. court has now given the attorneys the corrected entries as noted by Mr. Jones. I would like to, at this time, then make a record of the instructions as we number them. As it is my practice, as we go through these, I would invite either counsel to interrupt me and make a record as to any objections that you may have, so that a record can be made. The first page is instructions to the jury. Instruction 1, the defendant has been. Instruction 2, the trial information. Instruction 3, the defendant is. Instruction 4, the defendant has. Instruction 5, these instructions define. Instruction 6, nothing I have said. Instruction 7, you must determine. Instruction 8, the duty of the jury. Instruction 9, whenever I instruct. Instruction 10, the burden is on the state. Instruction 11, if there is a reasonable doubt. Instruction 12, ye shall base. Instruction 13, decide the facts. Instruction 14, in considering the evidence. Instruction 15, where two or more. Instruction 16, exhibits have been. Instruction 17, you have heard. Instruction 18, evidence has been. Instruction 19, the defendant cannot. Instruction 20, a person participates. Instruction 21, the specific intent instruction will come back and fill in those blanks. Instruction 22, general intent definition, once again, we'll fill in the blanks. Instruction 23, the marshalling instruction of murder in the first degree. Instruction 24, the definition of willful to deliberate and premeditate. Instruction number 25, deliberation and premeditation. Instruction 26, the definition of malice and malice aforethought. Instruction 27, the definition of a dangerous weapon. Instruction 28, if a person has. Instruction 29, malice aforethought. Instruction 30, the marshalling instruction for murder in the second degree. And instruction number 23, the last blank should be filled in with the number 30.
Sorry, Judge, did you say 23? That 23 was the murder one marshalling instruction.
Correct. So you would go back to 23 and fill in 30.
Oh, I see. All right.
Instruction 31, murder in the second degree does not. Instruction 32, the marshalling instruction for voluntary manslaughter. Then you would go back to instruction 30 and fill in the blank with 32 at the end. Then instruction 33, This is the serious provocation definition, and I believe the proper way to fill in the blanks would be to say concerning element number 3 of instruction 32. And then instruction 34 is the marshalling instruction of, for the charge of involuntary manslaughter. Then you would go back to instruction 32 and fill in 34 on the blank at the end. Instruction 35, the definition of reckless or recklessly. Instruction 36, the marshalling instruction for domestic abuse assault with intent to inflict serious injury, and then all of the lesser includeds within that offense. Instruction 37, an element of the crime charged. Instruction 38, defining family or household members and cohabitating. Instruction 39, the defendant claims he was under the influence.
Your Honor, that's the point in time where I would raise my objection with respect to, it looks like paragraph 4 of proposed instruction number 39. Specifically, the additional language offered by the state, which is the last sentence, again identified as the 4th paragraph. Intoxication is not a defense to the crimes of murder in the 2nd degree, voluntary manslaughter, or involuntary manslaughter. The stock instruction, which is, I guess, the base with which we take these instructions from, offers paragraphs 1, 2, and 3, and does not have that additional 4th paragraph that is being proposed now. I attempt to act out of an abundance of caution, particularly where error can occur in a trial. I think that those things come up when additional language is offered that's not been sort of unanimously agreed to. So I'm always uneasy about any additional language, as I think that it, although I don't think it misstates the law, it's just not the current form of the instruction. So I guess with respect to that, that's where my concern lies and why I guess I'd object.
State.
Your Honor, it is a legally accurate statement of the law, and I think it will go a long way towards avoiding potential confusion as to which offenses intoxication would apply to.
Thank you. Mr. Puentes, I can understand your concern, but as discussed informally, we do our best with these instructions to give the jury a good roadmap of reaching their decision. We've provided them specific instructions as to specific intent and general intent as to the several offenses and lesser included offenses within these instructions. It's very clear our higher courts and Supreme Courts particularly prefer that we try to make our instructions as clear as possible to make it as easy as possible for the jury. And within those constructs, I do believe that with that specific language that everyone has agreed upon as to the specific intent and general intent definitions, I do believe to avoid any confusion by the jury and an erroneous decision by the jury, this language as proposed by the state, because we have those various offenses that have a general intent and specific intent crimes, that this language is appropriate. It's not a misstatement of the law, as both of you have indicated, and my view of, based on the evidence and the charges, is necessary to give a proper instruction to the jury. So your objection is noted but overruled. Instruction 40, beware of allowing your decision. And I would propose then, after reading instruction 40, that we proceed to closing arguments. Instruction 41, you may not communicate. 42, instruction 42, when you begin. Instruction 43, during the trial. Instruction 44, occasionally after a jury retires. Instruction 45, I am giving you 5 verdict forms for count 1 and 5 verdict forms under count 2. And it indicates in bold that they should only use 1 verdict form for each count, and then the verdict forms follow. Let's go back to instruction 21 and fill in those blanks. First blank would be filled in with number 23 for murder in the first degree. Would council agree that we should only have 2 blanks?
Yes, some of that was shifted by eliminating lessers, and I think also the domestic was a jumbo instruction covering 3 lessers all at once.
Would you agree, Mr. Puentes? All right, we'll alter that instruction to provide 2 blanks, and we'll fill that in with instruction number 23 and 36. And then on the general intent, and just to make the record clear on the state's proposed supplemental instructions, when talking about this instruction, the bottom paragraph should have noted general intent rather than specific intent. I think everybody understood that to be the case, but I wanted to make that very clear. So in 22, it would be instruction 30, 32, and 34. Would both sides agree with those numbers that are being noted?
Yes, Your Honor.
Yes, Your Honor.
Thank you. I will have instruction 21 changed to comply with what we've stated, and then we'll make a record on the final for everyone to approve. without Mr. Larson. It'll only be a moment. It will be very quick. Now that we've gone through the instructions, does the state approve these instructions?
Yes, Your Honor.
And Mr. Puentes, on behalf of the defense, other than your objection that has been noted and ruled upon, do you approve of these instructions?
We do, Your Honor.
All right. As they are now approved, I will give each side approximately 5 minutes to prepare then for their closing arguments, and then we'll bring the jury in. Thank you. So are both sides ready to proceed with instructions and closing arguments?
Yes, Your Honor.
Yes, Your Honor.
All right, we'll bring the jury in. Jury. And then the attorneys will be given an opportunity to give their closing arguments. You'll get a copy of these instructions to review once you go back to the jury room. And also when it comes to closing arguments, that is not evidence, so there should be no note-taking at that time. Evidence has permission charges the defendant in count 1 with the crime of murder in the first degree. The trial information charges the defendant in count 2 with the crime of domestic abuse assault with the intent to inflict serious injury. The trial information includes the lesser included offenses under count 1 of murder in the second degree, voluntary manslaughter, and involuntary manslaughter. The trial information includes the lesser included offenses under count 2 of assault with intent to inflict serious injury, domestic abuse assault, and assault. Instruction number 1. The defendant has been charged with 2 counts. This is just a method for bringing each of the charges to trial. If you find the defendant guilty or not guilty on either one of the 2 counts, you are not to conclude the defendant is guilty or not guilty on the other. You must determine whether the defendant is guilty or not guilty separately on each count. Instruction number 2. The trial information is the document that formally charges the defendant with a crime and is merely the method which the defendant is brought into court for trial. It is not evidence. Instruction number 3. The defendant is presumed innocent and not guilty. The presumption of innocence requires you to put aside all suspicion which might arise from the arrest, charge, or the present situation of the defendant. The presumption of innocence remains with the defendant throughout the trial unless the evidence establishes guilt beyond a reasonable doubt. Instruction number 4. The defendant has entered pleas of not guilty. The pleas of not guilty are a complete denial of the charges and places the burden on the state to prove guilt beyond a reasonable doubt. Instruction number 5. These instructions define certain words, terms, or phrases. The definitions are to be used by you for any word, term, or phrase which is not specifically defined. You are to use the ordinary common English language usage definition. Instruction number 6. Nothing I've said or done during the trial was intended to give any opinion as to the facts, proof, or what your verdict should be. Instruction number 7. You must determine whether the defendant is guilty or not guilty from the evidence and the law in these instructions. My duty is to tell you what the law is. Your duty is to accept and apply the law and to decide all fact questions. You must consider all the instructions together. No one instruction includes all the applicable law. As you consider the evidence, do not be influenced by any personal sympathy, bias, prejudices, or emotions. It is common to have hidden or implicit thoughts that help us form our opinions. You are making very important decisions in this case. You must evaluate the evidence carefully. You must avoid decisions based on things such as generalizations, gut feelings, prejudices, fears, sympathies, stereotypes, or inward or outward biases. The law demands that you return a just verdict based solely on the evidence, your reason, and common sense. and these instructions. As jurors, your sole duty is to find the truth and do justice. Instruction number 8, the duty of the jury is to determine if the defendant is guilty or not guilty. In the event of a guilty verdict, you have nothing to do with punishment. Instruction number 9, whenever I instruct you, the state must prove something, it must be by evidence beyond a reasonable doubt. If the state does not prove the defendant guilty beyond a reasonable doubt, your verdict must be not guilty. Instruction number 10, the burden is on the state to prove the defendant guilty beyond a reasonable doubt. A reasonable doubt is one that fairly and naturally arises from the evidence in the case, or from the lack or failure of the evidence produced by the state. If after a full and fair consideration of all the evidence, you are firmly convinced of the defendant's guilt, then you have no reasonable doubt, and you should find the defendant guilty. But if after a full and fair consideration of all the evidence in the case, or from the lack or failure of evidence produced by the state, you are not firmly convinced of the defendant's guilt, then you have a reasonable doubt, and you should find the defendant not guilty. Instruction number 11, if there is a reasonable doubt as to the degree of the crime, the defendant shall only be convicted of the degree for which there is no reasonable doubt. Instruction number 12, you shall base your verdict only upon the evidence in these instructions. Evidence is 1, testimony in person. 2, exhibits received by the court. You may examine the exhibits closely, but be careful not to alter or destroy them. 3, stipulations, which are agreements between the attorneys. Facts may be proved by direct evidence, circumstantial evidence, or a combination of both. Sometimes during a trial, references are made to pretrial statements and reports, witnesses' depositions, or other miscellaneous items. Only those things formally offered and received by the court are available to you during your deliberations. Documents or items read from or referred to which were not offered and received into evidence are not available to you. The following are not evidence. 1, statements, arguments, questions, and comments by the lawyers. 2, objections and rulings on objections. 3, any testimony I told you to disregard. 4, anything you saw or heard about this case outside the courtroom. Instruction number 13, decide the facts from the evidence. Consider the evidence using your observations, common sense, and experience. Try to reconcile any conflicts in the evidence, but if you cannot, accept the evidence you find more believable. In determining the facts, you may have to decide what testimony you believe. You may believe all, part, or none of any witness's testimony. Whether the state has met its burden of proof does not depend on the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. There are many factors which you may consider in deciding what testimony to believe. For example, whether the testimony is reasonable and consistent with other evidence you believe, whether a witness has made inconsistent statements, the witness's appearance, conduct, age, intelligence, memory, and knowledge of the facts, the witness's interest in the trial, their motive, candor, bias, and prejudice. Instruction number 14. In considering the evidence, make deductions and reach conclusions according to reason and common sense. Facts may be proved by direct evidence, circumstantial evidence, or both. Direct evidence is evidence from a witness who claims actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is evidence about a chain of facts which show a defendant is guilty or not guilty. The law makes no distinction between direct evidence and circumstantial evidence. Give all the evidence the weight and value you think it is entitled to receive. Instruction number 15. Where 2 or more alternative theories are presented, or where 2 or more facts would produce the same result, the law does not require each juror to agree as to which theory or facts lead to his or her verdict. It is the verdict itself which must be unanimous, not the theory or facts upon which it is based. Instruction number 16. Exhibits have been received in evidence and may be used by you during your deliberations for reference. You are not to tamper with, alter, or destroy any exhibits, and you will return them to the court attendant after your deliberations are concluded by leaving them in the jury room. Instruction number 17. You have heard testimony from persons described as experts. Persons who have become experts in a field because of their education and experience may give their opinion on matters in that field and the reasons for their opinions. Consider expert testimony just like any other testimony. You may accept it or reject it. You may give it as much weight as you think it deserves, considering the witness's education and experience, the reasons given for the opinion, and other evidence in the case. Instruction number 18. Evidence has been offered to show the defendant made statements at an earlier time and place. If you find any of the statements were made, then you may consider them as part of the evidence. You may also use these statements to help you decide if you believe the defendant. You may disregard all or any part of the defendant's testimony if you find the statements were made and were inconsistent with the defendant's testimony given at trial, but you are not required to do so. Do not disregard the defendant's testimony if other evidence you believe supports it or you believe it for any other reason. Instruction number 19. The defendant cannot be convicted by confession alone. There must be other evidence the defendant committed the crime. In determining the weight and believability of the confession, you should consider 1. Defendant's mental capacity and intelligence. 2. Defendant's mental and emotional state at the time it was made. 3. Whether it was knowingly and intelligently made. 4. Whether the defendant understood it. 5. Any other evidence relating to the confession. Instruction number 20. A person participates in a crime beginning with the first act done toward the commission of the crime and ending when a person has been arrested or has escaped from pursuers. A person participates in a crime regardless if he is successful in committing it. Instruction 21. Concerning only instruction numbers 23 and 36, specific intent means not only being aware of doing an act and doing it voluntarily, but in addition doing it with a specific purpose in mind. Because determining the defendant's specific intent requires you to decide what he was thinking when the act was done, it is seldom capable of direct proof. Therefore, you should consider the facts and circumstances surrounding the act to determine the defendant's specific intent. You may, but are not required to, conclude a person intends the natural results of his acts. Instruction number 22. Concerning only instructions numbers 30, 32, and 34, to commit a crime, a person must intend to do an act which is against the law. While it is not necessary that a person knows the act is against the law, it is necessary that the person was aware he was doing the act and he did it voluntarily, not by mistake or accident. You may, but are not required to, conclude a person intends the natural results of his acts. Instruction number 23. Under count 1, the state must prove all the following elements of murder in the first degree. 1. On or about the 13th day of March, 2024, the defendant stabbed Taylor Escontrias with a screwdriver and or a knife and or hit her with a bat. 2. Taylor Escontrias died as a result of being stabbed with a screwdriver and or knife and or being hit with a bat. 3. The defendant acted with malice aforethought. 4. The defendant acted willfully, deliberately, premeditatedly, and with specific intent to kill Taylor Escontrias. If the state has proved all the elements, the defendant is guilty of murder in the first degree. If the state has failed to prove any one of the elements, the defendant is not guilty of murder in the first degree, and you will then consider the charge of murder in the second degree as explained in Instruction 30. Instruction number 24. Willful means intentional or by fixed design or purpose and not accidental. To deliberate is to weigh in one's mind, to consider, to contemplate, or to reflect. Premeditate is to think or ponder upon a matter before acting. Instruction number 25. Deliberation and premeditation need not exist for any particular length of time before the act. Instruction number 26. Malice is a state of mind which leads one to intentionally do a wrongful act to the injury of another or disregard of the rights of another out of actual hatred or with an evil or unlawful purpose. It may be established by evidence of actual hatred or by proof of a deliberate or fixed intent to do injury. It may be found from the acts and conduct of the defendant and the means used in doing the wrongful and injurious act. Malice requires only such deliberation that would make a person appreciate and understand the nature of the act and its consequences, as distinguished from an act done in the heat of passion. Malice aforethought is a fixed purpose or design to do some physical harm to another which exists before the act is committed. It does not have to exist for any particular length of time. Instruction number 27. A dangerous weapon is any device or instrument designed primarily for use in inflicting death or injury, and when used in its designed manner is capable of inflicting death. It is also any sort of instrument or device actually used in such a way as to indicate the user intended to inflict death or serious injury, and when so used is capable of inflicting death. Instruction number 28. If a person has the opportunity to deliberate and use a dangerous weapon against another, resulting in death, you may, but are not required to, infer that the weapon was used with malice, premeditation, and specific intent to kill. Instruction number 29. Malice aforethought may be inferred from the defendant's use of a dangerous weapon. Instruction number 30. The state must prove all the following elements of the lesser included offense of murder in the second degree under count 1. 1. On or about the 13th day of March 2024, the defendant stabbed Taylor Escontrias with a screwdriver and or a knife and or hit her with a bat. 2. Taylor Escontrias died as a result of being stabbed with a screwdriver and or knife and or being hit with a bat. 3. The defendant acted with malice aforethought. If the state has proved all the elements, the defendant is guilty of the lesser included offense of murder in the second degree under count 1. If the state has failed to prove any one of the elements, the defendant is not guilty of murder in the second degree, and you will then consider the charge of voluntary manslaughter as explained in instruction number 32. Instruction number 31. Murder in the second degree does not require specific intent to kill another person. Instruction number 32. The state must prove all the following elements of the lesser included offense of voluntary manslaughter under count 1. 1. On or about the 13th day of March 2024, the defendant intentionally stabbed Taylor Escontrias with a screwdriver and or knife and or hit her with a bat. 2. Taylor Escontrias died as a result of being stabbed with a screwdriver and or knife and or being hit with a bat. 3. The stabbing and or hitting of Taylor Escontrias was done solely by reason of sudden, violent, and irresistible passion resulting from serious provocation. If the state has proved all of the elements, the defendant is guilty of the lesser included offense of voluntary manslaughter under count 1. If the state has failed to prove any of the elements, the defendant is not guilty of voluntary manslaughter, and you shall consider the charge of involuntary manslaughter as explained in instruction number 34. Instruction number 33. Concerning element number 3 of instruction number 32, a serious provocation is conduct that would cause a reasonable person to have a sudden, violent, and irresistible passion. Passion is not sudden, violent, and irresistible if there is an interval of time during which a reasonable person would, under the circumstances, have time to reflect and bring his passion under control and suppress the impulse to kill. Words alone, however abusive or insulting, cannot be serious provocation. Instruction number 34. The state must prove all of the following elements of the lesser included offense of involuntary manslaughter under count 1. 1. On or about the 13th day of March 2024, the defendant recklessly stabbed Taylor Escontrias with a screwdriver and or knife and or hit her with a bat. 2. The defendant did the act in a manner likely to cause death. 3, by doing the act, the defendant unintentionally caused the death of Taylor Escontrias. If the state has proved all of the elements, the defendant is guilty of the lesser included offense of involuntary manslaughter under count 1. If the state has failed to prove any one of the elements, the defendant is not guilty under count 1. Instruction number 35, a person is reckless or acts recklessly when he willfully disregards the safety of persons or property. It is more than a lack of reasonable care which may cause unintentional injury. Recklessness is conduct which is consciously done with willful disregard of the consequences. For recklessness to exist, the act must be highly dangerous. In addition, the danger must be obvious, that the actor knows or should reasonably foresee that harm will more likely than not result from the act. Though reckless is willful, it is not intentional in the sense that harm is intended to result. Instruction number 36, the state must prove all the following elements of the crime of domestic abuse assault with intent to inflict serious injury under count 2. 1, on or about the 13th day of March 2024, the defendant did an act which was meant to cause pain or injury, result in physical conduct which was insulting or offensive, or place Taylor Escontrias in fear of immediate physical contact, which would have been painful, injurious, insulting, or offensive to Taylor Escontrias. 2, the defendant had the apparent ability to do the act. 3, at the time the defendant intended to cause serious injury to Taylor Escontrias. 4, the act occurred between family or household members who resided together at the time of the incident. If the state has proved all of these numbered elements, the defendant is guilty of domestic abuse assault with intent to inflict serious injury. If the state has proved only elements 1, 2, and 3, then the defendant is guilty of assault with intent to inflict serious injury. If the state has proved only elements 1, 2, and 4, the defendant is guilty of domestic abuse assault. If the state has proved only elements 1 and 2, the defendant is guilty of assault. If the state has failed to prove either element 1 or 2, the defendant is not guilty under count 2. Instruction number 37. An element of the crime charged is that the victim suffered a serious injury. A serious injury is a disabling mental illness, a condition which cripples, incapacitates, weakens, or destroys a person's normal mental functions, a bodily injury which creates a substantial risk of death, or which causes serious permanent disfigurement or extended loss of impairment of the function of any body part or organ. Instruction number 38. The law defines family or household members as persons cohabitating with each other. Cohabitating does not require a sexual relationship, but does require more than dwelling or living together in the same place. To determine if the defendant and Taylor Escontrias were cohabitating at the time of the alleged offense, you may consider whether they had a sexual relations while sharing the same living quarters, they shared income or expenses, they jointly used or owned property together, they held themselves out as husband and wife, the continuity and length of their relationship, and any other facts shown by the evidence bearing on their relationship with each other. Instruction number 39. The defendant claims he was under the influence of intoxicants at the time of the alleged crime. The fact that a person is under the influence of intoxicants does not excuse nor aggravate his guilt. Even if a person is under the influence of an intoxicant, he is responsible for his act if he has had sufficient mental capacity to form the specific intent necessary to the crime charged and had the specific intent before he fell under the influence of the intoxicant and then committed the act. Intoxication is a defense only when it causes a mental disability which makes the person incapable of forming the specific intent. No amount of intoxicants or drugs taken voluntarily can reduce second-degree murder to manslaughter. Intoxication is not a defense to the crimes of murder in the second degree, voluntary manslaughter, or involuntary manslaughter. Instruction number 40. Beware of allowing your decisions to be influenced by implicit biases. Everyone, including me, has certain unconscious attitudes and assumptions, perceptions, fears, and stereotypes. These preconceptions can impact what we see and hear, how we remember what we see and hear, how we make important decisions. Because you are making very important decisions in this case, I strongly encourage you to evaluate the evidence carefully and to resist jumping to conclusions based on personal likes or dislikes, generalizations, gut feelings, sympathies, stereotypes, or biases. The law demands that you return a just verdict based solely on the evidence, your individual evaluation of that evidence, your reason and common sense, and the court's jury instructions. Our system of justice is counting on you to render a fair decision based on the law and the evidence, not on biases. Therefore, challenge your own conclusions to be certain they are based on evidence and not upon suspicious attitude or bias. One way to do this is to ask yourself if your conclusion would remain the same if the person's sex, race, religion, sexual orientation, national origin, age, or disability were more like your own. Ladies and gentlemen, it's now time for the attorneys to present their closing arguments or summations of the evidence. Counsel for the state will have the opening summation. Counsel for the defendant will then have an opportunity to reply. And since the defense will only address you once, this address will also include their summation. The state gets the last summation since it has the burden of proof. The attorneys will be summarizing the testimony that you have heard and the evidence which was presented during the course of the trial. They are merely recalling the evidence as you will later. They will not intentionally try to mislead you, and if their recollection of the testimony is not the same as yours, you must follow and rely on your own recollection. The summations of counsel are just that, summations. They are not evidence. They are intended to help you understand the claims of both sides. Please give them your close attention now. Mr. Larson.
Thank you, Your Honor. May it please the court. Mr. Puentes, Ms. Kriegel, members of the jury. Taylor's blood is on the defendant's hands, both in the literal sense that the swab Deputy Rowling took retrieved her blood off of his hand the next morning, and the DCI analyst or criminalist determined that was Taylor's blood, and also in the figurative sense, and that the defendant is clearly responsible for Taylor's death. I want to go through a timeline of some important events that you learned about during the course of this trial. Then we'll talk about some of the instructions in law and how those facts apply to each charge of this case, and some different questions or different thoughts you might have regarding how the law applies to this case. I'm not going to read the instructions to you. Obviously, Judge Latham just did that. You're also going to have the instructions to bring back with you in the jury room. 11:34 p.m. Taylor sends a text message to Nick Seaman saying, "If I get killed, it was Chris." You remember we had the screenshot from Nick Seaman's phone. We also had the Facebook returns from both Mr. Seaman and Taylor. Remember that return showed that the message was deleted off of Taylor's phone. Now, whether that was Taylor deleting it herself because she was scared of the defendant fighting it, or whether the defendant deleted it after Taylor had died or during the altercation, that we're not sure of. At 11:35, or sometime after the message to Mr. Seaman, she also contacts Mike Holland about getting picked up. Mr. Holland was drinking that night, wasn't able to, but again, Taylor's reaching out for help at this point because she clearly knows that she's in danger. At approximately 1:42 a.m., so sometime between the Holland calls and 1:42 a.m., we know that Taylor is likely deceased by this point. The defendant crashes his Impala just outside the weather station. And again, we know that time from the footage outside the weather station. We heard that from Mike Lemon. I did include exhibit numbers for a lot of the evidence that I'm going to reference. You're going to have all the exhibits back with you when you're deliberating, as far as all the video, all the pictures, all of the physical items of evidence. So I'd encourage you to go through that as well. 12 minutes later, Lieutenant Leonard arrives on scene. He observes the defendant as likely being intoxicated. He also finds this knife, Exhibit 29, on the floor of that Impala on the driver's seat. And again, that was later determined to have Taylor's blood still on it at that time. If you remember, when Lieutenant Leonard arrived on scene, it was a very rainy night, which is why you likely don't see a large amount of blood on that knife. When Lieutenant Leonard first saw the knife, he had no idea about where that knife would go. He thought it was, again, a relatively routine OWI investigation, removed the knife for his safety and the defendant's, set it on top of the vehicle, clearly exposed to the rain. So it's likely that that knife had a lot more blood on it before that point. But again, Lieutenant Leonard was not investigating a homicide at that time. He observed the defendant to be barefoot, which at that time he interpreted as evidence of the defendant being intoxicated. It's also evidence of the defendant potentially leaving the apartment in a hurry, didn't have time to put his shoes on. At 2:36 a.m., Deputy Raby does a welfare check at the 105 Crestview address. He knocks on the door, I think he said 2 or 3 times, I don't remember the exact amount. No one answers. He clears that call and moves on with his day. Meanwhile, at the hospital, the defendant starts making concerning statements to Deputy Turner. And that's found on Exhibit 1, which is Deputy Turner's body cam. He tells, I think it was the nurse that was attending to the defendant at that time, he says, "I'm the piece of shit here." Asks, "Was I covered in blood?" He asked Deputy Turner to again check on the apartment to see if Taylor's okay. And then tells him that something in my mind makes me feel like I did something. Even if the defendant didn't remember what happened on March 13th and 14th in the witness stand, at this point and throughout this investigation, he certainly remembered what had happened and what he did. He goes on to say, "I have these pictures in my head that I beat her with the baseball bat," and acknowledged that was the same bat found in Exhibit 23. I'm not going to hold it up because I don't think it's secured in there all that well. I don't want it to fall out. And then he starts saying, and then he kind of stops. He says, "If anything that I did that's going through my head," and then trails off. After seeing the evidence, where do you think the defendant's mind was going with at least the beginning of that statement? And then at 4:11 a.m., Taylor's body is discovered by Deputy Slagle and also Lieutenant Leonard. And then 9:57 a.m. or later that morning was that interview with Detective, now Deputy Rolling. We also heard from Detective Alex Grease. He documented the scene, collected evidence from the scene, and facilitated getting evidence to the DCI lab for DCI testing or DNA testing. I went a little bit out of order, but he also took swabs of suspected bloodstains from all over the apartment with the assistance of Sergeant Wall, who you did not hear from. We heard from Dr. Hari. She's a Scott County medical examiner. She ordered the autopsy. You heard her testify that that's essentially her role was to investigate suspicious deaths and when appropriate to order that autopsy. She also prepared Taylor's body for transport to the state medical examiner. And in doing so, she placed paper bags over Taylor's hands and also properly secured that body bag, so we know that her body was not tampered with between leaving the scene and getting to the state medical examiner, where her autopsy was done by Dr. Dennis Klein. You've got access to the autopsy report, which is Exhibit 13. He talked about the extensive injuries that Taylor's body had on it. She had 23 stab wounds from a screwdriver, 17 stab wounds from a knife, and multiple blunt force injuries likely inflicted by a baseball bat. We can't give you an exact number based on the injuries, of how many times Taylor was struck by that baseball bat. The defendant, in his interview with Detective Rowling, estimated it was maybe about 6. From the evidence presented by Dr. Klein, that would be a low number based on the injuries that she had. He also told you that her cause of death was multiple blunt and sharp force injuries, which I don't think we needed a medical doctor to tell us based on the photos that we saw. And the manner of death, as he said, was homicide. That's not a legal determination, it's just a determination that someone inflicted this death on Taylor. I want to talk about some of that interview with Detective Rowling. And like I told you before, you're going to have access to all this back in the jury room. I'd encourage you to rewatch this interview, but I want to show you a couple different clips. And you can kind of break the interview up into 2 different parts. We have the first part, the first story the defendant says, and then he says, oh, I made all that stuff up.
Okay, I'm gonna be honest with you. I don't know what happened from the time that we went to bed to the time that I hit her with the baseball bat. I kind of made up that stuff in between.
That's important. It shows the defendant knows he did something terrible the night before. It shows that, at least for the first part, he knows he's got to make up a story to try to get out of that. That first story is not important in explaining what happened. You heard Detective Rowling talk about how the first story that he told didn't line up with the evidence on the scene, specifically where they found blood pools and where they knew Taylor bled at. The second story, however, did. I don't think Detective Rowling actually testified to that, but again, review that second story that the defendant told. Essentially, all of the major components fit within what was found on the scene. He talked about beating her with the bat by the door as one example. Clearly, that certainly fits with what we saw on scene, where we saw Taylor's body and the injuries that we saw. You remember at this point, Detective Rowling essentially starts the the interview over with the defendant, because at that point he says everything I made up, so he starts over.
This whole, we'll back up then. So you said, from you laying down,
Yeah.
the next thing you remember is hitting her with a bat.
Yeah.
Where did that happen?
In the living room. In front of the couch area.
It looks like I didn't place my video very well there, but the defendant in this interview remembers waking up and hitting Taylor with the bat.
That's the only thing I could think of is why, like, something happened. It's like, maybe she said something, I don't know, I have no idea, because all I remember is waking up and I was hitting her with a bat in the living room. I don't remember anything before that, other than laying down.
The defendant even goes so far as to show how he hit Taylor with the bat by demonstrating the chopping motion that he used.
When you hit her, was she facing you? Was she facing away?
I think she was facing away.
Where was she at? Was she standing, kneeling, laying down?
I think she was trying to go for the door.
So do you think, was she like standing or?
And she was on the ground, like either crawling or kneeling.
So you said that the next thing you remember is hitting her with a bat. Are you left-handed or right-handed? Or you're right-handed? Okay. So, do you know how, like, do you remember how you were swinging it? Like,
I think it was just like a chopping motion.
just like straight up and down? Okay.
The defendant even explains why he stopped swinging the bat. If you remember, he stopped the bat because Taylor stopped screaming. Whether the screaming stopped first or whether he stopped swinging first, not entirely sure, but that was his explanation.
When did she stop screaming?
I stopped swinging the bat. And do you remember, did you have to go get the knife from someplace, or? I just remember having the knife and stabbing her. I don't know where I got it from. The only thing I know is that the knife, the last place I knew where it was before all of this was in the kitchen, drying next to the sink.
Okay. So you said she stopped screaming when you stopped swinging the bat. And then after that, you stabbed her. If she stopped screaming, why did you stab her after that?
I can't speak to what the fuck was going through my fucked up head at that point.
And my clip cut off a few seconds early, but the defendant goes on to explain that he at least gives one possible reason why he might have stabbed her, and that was because he already did as much damage as he did, he might as well put her out of her misery. And the state acknowledges that there is some room there for the defendant to say that wasn't admitting why he stabbed her, but why do you think he said that? When the defendant doesn't remember something, just doesn't remember, period, he says that to Detective Rowling. Like with the screwdriver, he admits that he doesn't remember the screwdriver and he doesn't try to fill in those gaps. So when he tells you that he might have stabbed Taylor to put her out of her misery, that's the defendant telling you that he stabbed her to put her out of her misery. We heard from DCI criminalist Stanton Freilinger, is I think how you say his name. The exhibit is 11C that you'll have back with you. His testimony was essentially that Taylor's blood and DNA was found all over the apartment. I didn't list every single tent where her DNA was found because you saw the pictures, you heard the testimony, it was all over that apartment. It was on the knife that was found on the defendant's vehicle that we've already talked about. It was on the baseball bat that we talked about. And it was on the screwdriver. The next day, it was also found on the defendant's right hand. Also the defendant's shorts. I want to talk about what is evidence. It's a term that I think we take for granted when we talk about hearing evidence or seeing evidence, but there are instructions on that. Evidence is testimony, so what you heard people testify to throughout the course of this trial, that's evidence. That's exhibits, that's all of these, who our court attendants done a very good job of organizing. I think you probably saw them a few days ago when they were all over the table. So that would include pictures, the body camera footage, security footage, the actual items. You even got the blood swabs. Those are all exhibits that you'll have to take back with you to deliberate over. It's also the defendant's statements during the Detective Rowling's interview. And that's found in instruction number 18. So the interview that you heard with Detective Rowling, you can consider that as evidence, just as you can consider his testimony that he made in that chair earlier today. The instructions also talked about direct versus circumstantial evidence. And essentially, the law does not make a distinction between those two things. It's up to you to decide what weight each piece of evidence has, whether it's direct or circumstantial. You've got an instruction on reasonable doubt, which I didn't get the number up there, but it is in your packet, I promise. I'm not going to read the whole instruction to you. It's a fairly long paragraph, The operative term there is firmly convinced. If you're firmly convinced of something, you have no reasonable doubt. Like we talked in jury selection, that is not beyond all doubt. It's firmly convinced. Let's talk about the charges. We have 2 counts. Count 1, murder in the first degree. Count 2, domestic abuse assault with intent to cause a serious injury. Each one of those counts has what are called lesser included offenses. So under count 1, murder in the first degree, included in that is murder in the second degree, voluntary manslaughter, and involuntary manslaughter. And you can think of it as more or less a ladder. And we're going to start at the top of the ladder, and you're instructed to consider murder in the first degree first. Only if you find the defendant's not guilty of murder in the first degree, then you move to murder in the second degree. So if you find he's guilty of murder in the first degree, your work on count 1 is done. You don't have to go any farther than that. After count 1, then you'd move on, after the murder first degree, then you'd move on to murder second degree if you find him not guilty of murder first. And then from there you go down to the 2 manslaughter charges. And then under count 2, the 3 lesser included offenses are assault with intent to inflict serious injury, domestic abuse assault, and assault. Murder in the first degree has 4 elements. This is called the marshalling instruction. And this is essentially where you can kind of check off whether the state has met all the elements. It's got 4 different elements. First, the defendant stabbed Taylor Escontrias with a screwdriver and or knife and or baseball bat. Number 2, that as a result, Taylor died. Element 3, that the defendant acted with malice aforethought. And element 4, that the defendant acted willfully, deliberately, premeditatedly, I think I said that correctly, and with a specific intent to kill Taylor Escontrias. I want to talk about each 4 of those instructions, or each 4 of those elements separately. So let's start with element 1. That the defendant stabbed Taylor Escontrias with a screwdriver and or knife and or struck her with a baseball bat. What evidence do we have that the state has met its burden on the first element? Well, first, we have that he had one of the murder weapons in his possession when he first encountered law enforcement, that being the knife. He had access to the other 2. The other 2 were located within the apartment where the defendant admitted both today and back with Deputy Rolling that he lived. He had Taylor's blood on his right hand and clothing. He clearly had knowledge of Taylor's injuries. The defendant can say he did or didn't remember about anything. It's clear from that interview with Detective Rolling and also his conversation or statement to Deputy Turner that he had knowledge of Taylor's injuries. And how else would he know about her injuries unless he inflicted them? We've got no evidence of an intruder or anything of that nature that would point to anyone else. Like I said, we have the statements at the hospital and also with Detective Rolling. We also know that Taylor was frightened that night, again, due to the phone calls and text messages to her friends that you heard about. Specifically, if I get killed tonight, it was Chris. That was a direct quote from a message to Nick Seaman. It's also important to note that the defendant does not deny killing Taylor. He didn't deny on March 14th, 2024, and he didn't really deny it in his testimony today either. Members of the jury, there is no reasonable doubt that the state's met burden 1. You should all be firmly convinced that element 1 is established beyond a reasonable doubt. Element 2, that Taylor died as a result of being stabbed with a screwdriver and or knife and or hit with a baseball bat. What evidence do we have of that? Well, we have Dr. Klein's testimony. He talks about her injuries, her being stabbed 40 times with a screwdriver and the knife collectively, and also multiple blunt force injuries, again, likely inflicted with that baseball bat. He opined that the cause of death was multiple blunt and sharp force injuries, which, as I alluded to earlier, I think probably anyone with common sense could probably have established that as well, just by seeing those photographs of both the scene and seeing the injuries documented from that autopsy report. the state has met its burden on the second element as well. And to be quite honest, there isn't much argument that the state has not met its burden on these first two counts. The fighting issues are counts 3 and 4, so let's talk about those. Third element, keep saying counts, be the third and fourth elements. Third element is the defendant acted with malice aforethought. Luckily, that is defined in our instructions. Malice is a state of mind which leads one to intentionally do a wrongful act to the injury of another. It's out of hatred or with an evil or unlawful purpose. This is all taken from the instructions. This is not me giving you my opinion. This is from the instructions. It can be found from the acts and conduct of the defendant and the means used in doing the wrongful and injurious act. And it only requires such deliberation that would make a person appreciate and understand the nature of the act and its consequences. Similarly, malice aforethought is a fixed purpose to do some harm which exists before the act is committed. It does not have to exist for any particular length of time. So let's talk about the unlawful purpose, again, from the instruction. Well, the evidence showed that the defendant hit Taylor with a bat as she was trying to escape the apartment, as she was likely trying to escape the apartment. She was stabbed in her throat area after her screaming stopped, again, once the defendant stopped swinging the bat. There was no lawful purpose for doing either one of those things, and I'm not saying those are the only two things. I'm just trying to illustrate points that I think there's a lot of unlawful purpose that happened in, that you heard about throughout the course of this case. You can also consider the acts and conduct of the defendant and the means used to do that unlawful purpose. Again, we have 40 stab wounds plus the blunt force injuries. Some, as Dr. Klein testified to, were with severe force. And we cannot quantify that, but he did make a distinction between severe force and moderate force. A lot of these had severe force behind them. The assault took place throughout the apartment. That shows that this is not something that was done over a short period of time, but a relatively long period of time. It's going to take time to inflict that many wounds over that many different areas of the apartment. And again, it only requires such deliberation that would make a person appreciate and understand the nature of the act and its consequences. I put this up here again because this is what we call a reasonable person standard. So it's not whether the defendant appreciated, it's whether a reasonable person would have appreciated it. Clearly, a reasonable person or a person would appreciate and understand the nature of the acts and its consequences, as you heard about over the course of the last week or so. He switched weapons at least 2 times because he used 3 different weapons. And then the deleted messages, and I put a question mark behind that. Does it show that the defendant understood what he did and needed to cover up his tracks by deleting those messages? We know that the defendant knew that there was no passcode on Taylor's phone, so he would have had access to that. But again, it also could have been Taylor deleting the messages so that he didn't see them and perhaps cause more anger or cause the assault to get worse. We don't know that. We do know that he hit Taylor's phone. If I remember correctly, the phone was found on the bed underneath either a pillow or a blanket. I don't remember which. I think it's safe to assume that Taylor did not put her phone there. You saw how bloody that phone was from the photographs. Would have been the defendant putting the phone there after Taylor was either incapacitated or after she had died. And after he killed the defendant, or after he killed Taylor, the defendant fled the scene. That's an important fact because it shows the defendant understood exactly what he did and they knew he had to get away so the cops didn't get him. You heard that statement in Detective Rolling's interview. Now, I understand that that's after the assault would have taken place, but unless the defendant all of a sudden came to after the assault and realized what happened, that shows what the defendant's likely state of mind was during the assault, and that he would have understood what he was doing as he was beating Taylor to death. I put the quote from the video on there. Again, the defendant, he pushed back on this when Mr. Jones was questioning him this morning. But review that clip. The defendant says that he debated on if he was going to lay down, and then was like, no, then the cops are going to get me. In that interview, the defendant tells you that's what he's thinking. And again, it shows he appreciated and understood the acts and consequences of what he had just done. It also shows that he's able to form specific intent. Again, you need to project that backwards just a little bit because this is after Taylor died. But if he's understanding what he did after Taylor had died, he certainly understood what he was doing while he was inflicting all of the injuries that you saw evidence of. And then the defendant chose to leave. That was a voluntary act for the defendant to leave, again, as he explained, which is important because it shows the defendant was capable of doing voluntary acts, even if he doesn't remember all the details necessarily. Going on to malice aforethought, which is a fixed purpose to do some harm, which exists before the act is committed. It does not have to exist for any particular length of time. Again, the assault, I'm starting to sound like a broken record because a lot of these apply to multiple counts, but the assault took place with multiple weapons over multiple areas of the apartment. The defendant admits to stabbing Taylor's throat after seeing how injured she is. And even if you accept that the defendant did not know what he was doing up until that point, he said that he came to, saw Taylor injured, and then he decided to put her out of her misery. Iowa law does not recognize a mercy killing or anything of that nature. The defendant could have called 911. He could have rendered first aid of some sort. But no, what does the defendant do? He decides he's going to put her out of her misery and stab her in the throat. There's an instruction, and this is a direct quote, that malice aforethought may be inferred from the use of a dangerous weapon. And you have dangerous weapon also defined for you in the instructions. A knife is a dangerous weapon. A screwdriver, when used to stab someone, is a dangerous weapon. And certainly a baseball bat, when you're using it to beat someone, is a dangerous weapon. So you can use the fact that the defendant used a dangerous weapon, let alone 3, to infer malice aforethought. Members of the jury, the state has proved beyond a reasonable doubt that the defendant acted with malice aforethought. Let's move on to the 4th element. That the defendant acted willfully, deliberately, premeditatedly, and with a specific intent to kill Taylor Escontrias. We can look at the nature of the crime. Clearly this is a willful action. This isn't something that happened by accident. Despite what the defendant may want you to believe, this is not the actions of someone that's so drunk that they don't know what they're doing. 3 weapons, multiple areas of the apartment, does not render aid. And again, like malice aforethought, does not need to exist for any determined amount of time before the act. So that can be an instant, it can be a second, it can be planned for weeks. Obviously, this is not a case where we have the planning or the premeditation for weeks or days. We're talking hours or minutes at this point. Willful, deliberate, and premeditate. I think I might have misspelled that. There are instructions on that as well. Willful is by a fixed design, on purpose, not accidental. Nothing about this crime was accidental. She had 40 stab wounds, multiple blunt force injuries. That does not happen by accident. Deliberate is defined as to weigh in one's mind, to consider, contemplate, or reflect. This is where you need to make some inferences based on the evidence, because we can't exactly say what was going on in the defendant's head. But there was certainly time for the defendant to deliberate. In between any one of those 40 stab wounds or the baseball bat strikes, the defendant could have likely deliberated on what he was doing. He likely deliberated when he switched weapons. Why does one switch weapons? Because the one you're using isn't working well enough for whatever you're trying to do. Otherwise, if the defendant wasn't thinking, there'd be no reason for the defendant to switch weapons. And then to premeditate, to think or ponder before acting. Again, this does not need to exist for any amount of time. At some point during the 40 stab wounds, multiple bat strikes, the defendant would have had time to think or ponder before he was doing that. And again, even if you take the defendant at his word, when he says he comes to and decides that he's going to stab Taylor to put her out of her misery, that's premeditation right there. This assault, as I stated before, it took time to complete. Plenty of time for the defendant to form the requisite mental state that he needs to be convicted for murder in the first degree. I got ahead of myself a little bit with some of those slides, but the state has met its burden on the fourth element, that the defendant acted willfully, deliberately, and premeditatedly, and with a specific intent to kill Taylor Escontrias. Why else would he have stabbed her 40 times and beat her with a bat? The defendant is guilty of murder in the first degree. Now, I suspect you'll hear about the intoxication defense a fair amount from the defense when they give their closing arguments, and I wanted to talk about that intoxication defense. You'll find that in instruction 39. It does not excuse or aggravate guilt, so it is what it is. The requisite question is whether the defendant had sufficient mental capacity to form specific intent. I want to go back to the elements, and then I'm jumping around, but I want to go back to the elements. As I told you before, this is what the state's required to prove for murder in the first degree. As we talked about in jury selection, the state's not required to prove motive. There was not a lot of evidence on motive, but we're not required to prove that. The defendant did make some statements about the relationship being kind of rocky, right around the time this happened. Whether that was a motive or not, nobody knows at this point except the defendant and perhaps Taylor, and Taylor can't tell you, obviously. We're also not required to prove that the defendant remembered what he did. Even if the defendant has no recollection of what happened, as he testified to today, we're not required to prove that. You heard Dr. Doyle's testimony. When someone's having a blackout, it doesn't necessarily mean that they don't know what they're doing, that they're robots without any control of their actions. He said that it blocks your brain from forming long-term memories. That's what a blackout is. It doesn't mean that the defendant didn't know what he was doing when he was doing it. It just means that he doesn't remember doing it. Not remembering doing something is not a defense. Intoxication is. And again, the specific, or the critical question is whether he had the requisite mental capacity to form specific intent. And that's the specific intent to kill Taylor. Again, let's look at the brutality of the crime. Number of weapons that he used, moving about the apartment. One thing we haven't talked about is the injuries on Taylor were in high value areas. This is not someone that's so drunk they don't know what they're doing and they happen to be swinging a bat around and it accidentally strikes Taylor. These are wounds clearly intended to inflict major damage on Taylor. There are many wounds around her head. You saw the screwdriver injuries on the back of her head where you can actually see the crosshatch, and also on her hands, likely as Taylor was trying to block the screwdriver from hitting her. The knife wounds, as the defendant told you in the interview, were in Taylor's neck. Again, this is not someone that's so drunk that can't form rational thoughts. The defendant knew what he was doing when he was doing this. He might not remember everything, but he certainly knew what he was doing at the time. And again, he also has the presence of mind to flee the scene with one of the murder weapons. And it's a weapon that the defendant admits was used last. We don't know for sure which weapon was used in which order, but the defendant talked about killing Taylor with that knife. He's found later that evening, whether that was minutes or an hour, we're not sure, but he was found later that evening with that same knife that he had missed killing Taylor with. So he knew to leave. He knew to bring at least a murder weapon he had in his hand. Now, nobody's saying this was the perfect crime, and maybe if he was completely sober, he would have thought to bring the other two murder weapons as well, but he didn't think to do that. He just thought to bring the one that he had in his hand. Despite being intoxicated, the defendant had a specific intent to kill Taylor. And not remembering what happened does not mean the defendant should be found not guilty. And again, the fact that alcohol lowers inhibitions does not mean that the defendant should be found not guilty. If there was no alcohol involved, it's likely Taylor would still be here. This is not a question about whether this is something that would have happened without alcohol. Clearly, alcohol played a role in this tragedy, but that does not excuse what the defendant did that night. And it doesn't mean that the defendant did not have the mental capacity to form specific intent to kill. With intoxication, it's not a defense to murder in the second degree, and that's in your instructions as well. So even if you accept the defendant's intoxication defense, it's not a defense to murder second degree, which is the next level below murder in the first degree. The instructions tell you that no amount of intoxicant taken voluntarily can reduce second degree murder to manslaughter. So in other words, if you're convinced, if you're firmly convinced that the defendant voluntarily consumed alcohol, you're not able to go from murder in the second degree down to the manslaughter charges. How do we know whether the defendant voluntarily consumed alcohol that night? I understand addiction is a terrible thing, but even though the defendant has alcoholism, and we're not disputing that, the defendant made a choice that day to consume alcohol, as he told Detective Rowling.
I remember making the choice. I remember making the choice to drink.
He says, I remember making the choice to drink. With murder in the second degree, that's essentially the same as murder in the first degree, except the fourth element is crossed off. So the first three elements are the exact same. I'm not going to go through each one of those elements again. Just know that it's the only difference between murder first and murder second is that fourth element. Moving on to count 2, which is domestic abuse assault with intent to cause serious injury. Again, we've got 4 elements. The first element was on or about the 13th day of March, 2024. The defendant did an act which was meant to cause pain or injury, result in physical contact, which was insulting or offensive, place Taylor Escontrias in fear of immediate physical contact, which would have been painful, injurious, insulting, or offensive to Taylor Escontrias. There's a lot of words there. Essentially what it means is, for purposes of this case, is the defendant actually hit her with the bat, stabbed her with a screwdriver, stabbed her with a knife. Any one of those things would satisfy the first element. Secondly, the defendant had the apparent ability to do the act. This element is easy as well. We know the defendant had the apparent ability to stab her with a screwdriver, to stab her with a knife, and beat her with a bat, because he actually did. He actually assaulted her with each of those 3 weapons. At that time, or element 3, that at that time, when again he was stabbing her and beating her, the defendant intended to cause a serious injury to Taylor Escontrias. Why else would you do that? There's only one reason to inflict those kind of injuries on someone, and that's to inflict serious injury. And lastly, that the act occurred between family or household members who resided together at the time of the incident. Family or household members is defined as essentially, think about it as a boyfriend, girlfriend living together. They share expenses, they share a bedroom, all of which you heard. This element is satisfied as well. The defendant and Taylor were family or household members at the time of the assault. The state has established beyond a reasonable doubt all 4 of the elements of domestic abuse assault with intent to inflict serious injury. Based on the evidence that you've seen over the last week, the state asks you to return a verdict of guilty to both count 1, murder in the 1st degree, and count 2, domestic abuse assault with intent to inflict a serious injury. Thank you.
Mr. Fuentes?
Maybe we just briefly approach.
You may. Thank you for your patience, ladies and gentlemen. We just had to take care of a technical issue. And Mr. Fuentes, are you ready to proceed?
Yes, Your Honor. Just want to make sure that it pops up. That might still be the state's. Perfect. Thank you. May it please the court, counsel, ladies and gentlemen of the jury, these have already been told to you are closing summations. The idea behind them is I'm just going to give you the summary, if you will, of our case. The case certainly as I see it. The case that obviously, or the manner in which I'm going to ask that you see it as well. This is really kind of my first and last opportunity to make my case. The way that the process is set up, because the state is burdened with proof, they get to go first, I get to go second, and they get to go last. So there isn't an opportunity for me to kind of reply or to rebut the state's arguments. I need to kind of present all of it right now, try to, in some cases, kind of like foreshadow what is to come and try to address those things. So you have an opportunity to at least consider our version, if you will.
With respect to this process, there's an instruction on it specifically that defines evidence. I think some of it Mr. Larson had already discussed with you. What's really important for a takeaway is that this is not evidence. Nothing I'm saying now is evidence. It is an attempt to summarize the evidence. The evidence is done. That is closed. The statements of counsel, either my own statements or Mr. Larson's statements, are not evidence. And we will make every effort, and again, Mr. Larson's done that already, I intend to do the same, to be as accurate as we can about what the evidence is. But certainly, if you should have a difference of opinion with anything I'm about to say, or anything that Mr. Larson has just said for that matter, it is important that you are the fact finders. So know that if there is a difference of opinion, this is just our argument. These are not facts. So go with your gut, go with your notes, go with your instincts, etc. Just going to start in the most obvious place, which is the presumption of innocence. We addressed that during the jury selection process. We kind of didn't really quiz you on it, but certainly discussed it with you so that you had some idea about what that means. The best way to describe it is just to use a similar but different word, which is assumption, which doesn't really help you. The jury instruction obviously does a better job of that. It has always been my position, and certainly I submit to you the same, which is he still maintains the presumption of innocence until you deliberate. And if at the time you deliberate you should conclude that the state has met their burden, then that's when it shifts. But even at this moment in time, I submit, he still maintains that presumption of innocence. That is the starting point for your deliberations. And then you take into account what you believe with respect to the state's evidence, and you kind of check that against the elements of the crimes, the marshalling instructions, if you will. The burden of proof, real simple. It's on the state to prove the defendant guilty beyond a reasonable doubt. There are almost inevitably going to be times where you at least will contemplate. You may not say it out loud. You may not talk to each other about it, but you're going to say, well, the defendant didn't. The defendant is not obligated to. The burden is on the state. It doesn't shift. It doesn't become a defense burden. So just kind of keep that in mind when you're contemplating your instructions. Reasonable doubt. This is the current state of the jury instruction minus some additional language. This is kind of the part in the middle, I believe, but read the entire instruction, obviously. It's a useful tool. The idea of the instructions is to provide you guidance, not necessarily to give you the answers, but to give you an idea as to sort of what things are to mean. In the event that there's a word that you don't understand, you're to use just the ordinary common usage. So the way in which you've used it historically. Because there's not a ton of guidance, I think what can be useful is something that was discussed again earlier. I don't remember if it was opening statements or if it was jury selection. Some of that has kind of gone by the wayside in my memory. But I do think it's useful just to talk about briefly. Reasonable doubt, the state's burden in a criminal case, is the highest burden in the land. It is the highest proof obligation. There is no higher proof obligation. There are different types of cases involving different things that are non-criminal in nature. They have different burdens of proof. So what we know is that there's a burden of proof referred to as a preponderance of evidence. We just know that it's more than 50%. So the easiest way to describe it is just kind of 50.1% or greater. That's just what it is. Clear and convincing is just defined as a high probability. They don't give a number. There's no specific number. I don't even know necessarily how you'd wrap up your mind around like a 75%. I don't know how we do that. We just know something's greater than half or it's not. And then there's beyond a reasonable doubt, which is less than absolute certainty. And there is no debate about that. They do not have to prove it beyond all doubt. That is not the instruction. That is not the state of the law. But it is certainly higher than a high probability. So at least keep that in mind, even if you don't necessarily find the former instruction incredibly useful. Verdict shall be based on the evidence. And again, this is something we talk about in jury selection. And if you haven't found already, I imagine you'll find at some point when you think back on this case that there are a lot of things that we talk to you about during jury selection that is not evidence but can be useful. And in some cases, it's kind of giving you breadcrumbs about what is to follow. This particular instruction talks about, and we addressed it, I always call it the facts over feelings instruction. It's kind of the easiest way, I think, to summarize this. It's telling you things that are not evidence and really not to be used in the deliberation process, but something we inherently use in every other aspect of our lives. But they do not belong here, which are things like personal likes or dislikes, sympathies, biases, prejudices, or emotions. And those are things that I would expect, again, naturally you would consider in a case like this. I'm sure you saw evidence or heard evidence that would naturally cause you to use these things, but in the process of a deliberation, you are not allowed to. We understand you're not robots, but you have to try with every ounce of your being to set those things aside and consider the facts for the facts. And you're to use things like reason and common sense. And what you'll find is, and I may touch on this later, I think of myself as an expert in the law. I don't think of myself as an expert in any other avenue. I'd like to think maybe someday I'll be an expert father, but I don't know even how you achieve that particular expertise. But you are allowed to use your reason and common sense. So I'd encourage you, in the event that maybe there's not expert testimony to support those things, again, just use your common sense, your reason. You're allowed to use those. I'd ask that you arm yourself with those when, again, you work yourself through the instructions. We talked about it, and I presented it in this way. I think I used that specific term. This is not a binary question. This is not an A or B. This is not just set up for that. I talked to you about existing kind of in the gray, the idea being not to excuse but to understand, and I ask you to expand your minds when you do those things, again, during the deliberation, because this process matters so much. This is not a guilty or innocent. Again, it's not presented to you in that way. Innocent, not guilty, it's not really in the cards under count one. And I'm not going to insult you by asking you to find defendant not guilty under count one. I'm just not going to do it. But in the same way, the law presents you 4 options, only 2 of which I submit to you are viable options. Viable options for you to conclude guilt. I submit to you involuntary manslaughter does not exist in this case. The jury instructions just simply don't match. There's a term used, reckless. You're not going to find a reckless behavior or activity. I'd love to give you an example of what could be reckless. Again, just use your reason and common sense, but it, again, does not apply here. I submit to you neither does murder in the first degree, and I'll get to that and I'll explain that to you. But it is our position, certainly, and you have to decide for yourselves, obviously it differs from the state, that the ceiling in this case is murder in the second degree, and the floor is voluntary manslaughter. And for those of you that are not familiar with those terms, it just means the highest we believe the state can achieve is murder in the second degree, and the lowest we believe they can achieve, again, is voluntary manslaughter. And I'll get to those here in a little bit. I just want to talk to you a little bit about kind of the 2 main characters, if you will, in this trial process. There's Taylor Escontrias and Christopher Behal. I don't know why I chose to use their first names, not their last, but I did. But these 2 met back in roughly 2022, at least that's what the evidence provides at this point. They met in an intox rehab facility. It's at that point that their relationship kind of took off, or at least shortly thereafter. I think what's important to note is just this, it's just an unhealthy relationship. And I don't mean in the way that they're arguing, but I mean at least the way in which it germinated. I don't think that necessarily 2 addicts should be together. Certainly they shouldn't try to find sobriety together. It sounds as though the 2 left the facility, and I think the testimony was within a day had went back to drinking and fallen into those same things that sort of got them there in the first place. And it sounds like they at least kind of find sobriety for a time, lose sobriety, maybe find it again, and maybe lose it again. But there's this cycle, or the cyclical nature to their relationship. And again, I don't think the state's contesting that they're alcoholics. I don't think the state's contesting that he was under the influence of alcohol. But just in case they did, just a few things that Dr. Klein had testified about, some that came in through other forms of evidence, and that is evidence of fatty livers in both of them, which is indicative of alcoholics. That was what was told by Dr. Klein. And then the high blood alcohol contents, both of which were greater than 300. And that's supported again by other pieces of evidence, but I don't think there's any question that more than 300 is an impaired and or intoxicated individual. Certainly there's variance from one person to the next. Each of you may react or respond differently to the same blood alcohol content. But again, I think that it was consistent among everybody that that's a high blood alcohol threshold that had been met. We know that these two are struggling. It sounds like they're both unemployed or at least having difficulty finding and maintaining employment. That their life is kind of coming apart, at least Mr. Beall's was. He testified to that, said the way that it sort of just unraveled everything. It was costing him jobs, getting him OWIs. It was just impacting every aspect of his life, and certainly struggling with alcoholism. And we know that there's evidence of self-loathing and depression, and I believe the testimony was both of them were suffering from this. But again, certainly Mr. Beall. And that's just kind of the beginning of this story. I submit to you, if you're looking for answers, you're not going to find them, unfortunately. State can't give them to you, and neither can I. There are these huge areas that there's just no one to really explain what happened. Law enforcement tries, certainly to the best of their ability to do so. Mr. Beall, to the extent that he can, tried both with law enforcement and in the courtroom setting. And obviously we don't have the opportunity to hear from Ms. Escontrias, and there's certainly no recording. So there's all this gray space. But I always have to be a little bit critical about expectations. And maybe my expectations are unfair. That's fine. I can live with that. But your expectations matter, and I just want to bring that at least to your attention with respect to these things, because I'm always looking for not only what can they prove, but what should they have proved, or like where should they have looked, just to give us the fullest version of events. And maybe these are questions that you don't inherently ask, but certainly questions that I do. And I would submit to you that after Christopher Behal started talking to law enforcement, after he gave the second statement, that being to now Deputy Rowling, at the time Detective Rowling, they stopped investigating. That was it. They had their guy. There was no need for any further investigation, any attempt to answer questions, to understand what took place within those four walls at 105 Crestview, I believe it was apartment 4. Now they presented you DNA, which was done after the fact, but I'll submit to you it's done in almost every case. And I'd submit to you that it wouldn't matter what that DNA came back and said. He was getting prosecuted for this offense, and they were going to make similar, if not identical, arguments to the ones that they've given you already. That is just kind of something where it looks scientific-y. It can be impressive, something you may see on television. But it's not presenting you anything you didn't already know. You'd suspect to find her blood in her apartment. It's where she lives, that's where she was, the blood was there, you've seen the photographs. There's not really any question about that. What are other things that I think are absent? And again, if you heard differently, go with your gut, go with your own notes. But I think it could have been a useful tool to get text messages from all involved. At least they presented messaging app information, but no text messages from either Taylor or Mr. Behal. It sounded like there was an issue with maybe the passcode for Mr. Behal's phone. I believe they got it, but it was inaccurate. But that doesn't stop law enforcement. They can subpoena those documents. There's other means to get phone information, and I think it could have been useful just to illustrate whether or not there was a tone, specific language that was used, any topics of conversation, just to sort of understand, is this something that had been building? Is this spontaneous? Is this new? Kind of what is the status of their relationship? What else was absent? Certainly a reconstructionist or any expert that could tell you what happened inside of that apartment complex. And then any investigation of events prior. Obviously, the idea just being, and I think I talked to certainly one of the law enforcement, I want to say it's Rolling, but forgive me if I'm mistaken about that, about sort of the plasma, about any of the stops they made, just to try to figure out, is there a consistency or is there an inconsistency with like his recall the entire day, kind of just to figure out what, you know, what they should and shouldn't believe, right? But they didn't present that to you. And I submit to you, to the degree that they think they know what happened in there, I think the less credible they come off, or at least I submit to you that's the case. Because they just don't have anyone who can testify definitively to those things. I think, and it's almost always my opinion, that police officers try to do the best they can, to the extent that they're capable. I think that Deputy Grease and Deputy Rolling are very likely good cops, and I take no issue with that. What I don't think, though, is that they're experts. And I think to the degree that they try to submit to you something they know that happened inside this apartment, they simply do not. I think my argument is supported at least by the testimony of the officers themselves. So Deputy Grease, I believe, had, I guess I'm not even sure if he had a degree from a college institution. Not necessary, but again, didn't have one. No master's, no PhD, no scientific, I guess, related undergrad or degree program. He was law enforcement trained throughout the entirety. He didn't conduct, at least as I'm aware, any experiments to, I guess, kind of confirm or reject any conclusions he may or may not make. So I think that's a deficiency, at least in the state's case. I also think that Deputy Rolling had an exhaustive resume about every digital forensics class that he took, and I believe there may have been one interrogation course in there, but nothing that would make him ideal for investigating a crime of this type. And I'm sure that there's probably other officers on duty who could, or certainly other experts the state has access to that may, but those were not used because, again, there was no need for them to do so, right? They deduced already that they had their guy, and the explanations didn't matter so much at that time. So let's talk about the messenger apps. I submit that this is not foreshadowing. I submit to you, at least at the time that these text messages are sent, there is no ongoing crime. And I submit it to you based on, again, reason and common sense. So I want to talk to you about a few things. So first of all, I think the timing is significant. The first text message, at least that they offered, was sent to Nick Seaman. I think it was 11:34 p.m. I think 11:35, if I'm not mistaken, is when Mr. Holland reached out to Taylor that evening. So first it's something to the effect like, if something happens to me, Chris did it, right? Which seems like something's escalating, right? Something serious going on at that particular time. But then Holland reaches out with a, hey, how you doing, or something to that effect. It's very casual in nature. There's no other interaction with Seaman other than that, because I believe the testimony was he was asleep, so he's not answering or responding. But there is a significant drop-off from, if something happens to me, it's Chris, and then just kind of, how are things, what's going on, and very casual in nature, which is suggestive to me that if it were serious and ongoing, she wouldn't be texting him back, and if she was, she'd be saying, get here immediately, something, like just some indicator that like he's losing control. So I think there's significance to that. I think what stands out also is the fact that she's able to call and text. Again, if she was, if it just went radio silent, I think it'd be more suggestive that at that point in time something's going on. But she's able at least to call and text. And there were 2 calls, I believe, placed to Mr. Holland. Maybe they were incoming, maybe they were outgoing. I don't remember specifically. But what was the takeaway for me is that both times Holland said that there was no background noise. So again, it's indicative to me, if you're using common sense and experience, that there's not an ongoing assault at this point in time. If there was, he would have heard it. Either he would have heard it in her voice, or he would have heard Beall in the background, none of which he testified to. We know that she didn't call or text 911, which is not a requirement, but certainly a little unusual. Perhaps, again, if you feel that your life is in danger, you're not texting someone you used to hang out with, you text the police. Or you just leave the apartment complex. And again, we know that at least the time that she's communicating with Holland from beginning to end, and I don't remember exactly how much time that took, but certainly she's not fighting with him then, so just leave. Which again suggests kind of the unseriousness of the text messages that she's sending out. It suggests to me, just like both of them testified, this is just how she talks sometimes. I think Holland said on numerous occasions he's gotten calls or texts just like this about various historical boyfriends that suggests this is just the way that she communicates. This is the way in which she acts. I think he said particularly when she's under the influence, which we know she was because her blood alcohol content was greater than 300 when she passed away. And we know that neither one of them took it seriously enough to take action. We know that because Holland, I don't think, ever communicated with a law enforcement entity other than obviously to produce his messenger app, and I think that was long after the investigation had started. And then Seaman, I believe, did reach out to law enforcement, but it was after first seeing some indicator on like a Facebook page or some outreach by law enforcement saying, hey, does anybody know anything? And he replied at that point, but certainly didn't make any effort to do that on his own. The message deletions, obviously it's been raised. I think even Mr. Larson indicated he's not sure who deleted those messages. I submit to you it was her. It was Taylor Escontrias. And I don't think it's like for a nefarious purpose, but I don't believe, or I submit to you, certainly, that it was not Mr. Behal. And why I say that is because if it were Behal, would it make sense to delete more than is necessary, A, and B, would it not make sense to delete any text messages with Holland that were similar in nature? Like, why delete partial texts, including innocuous texts about a liver or like a fucked up liver, I think is the terminology that was used. Read the exhibit for yourself. And then something about making a doctor's appointment. Those just, it wouldn't be useful. Like, I don't know what he would be trying to hide at that point. But it does seem useful if, you know, it's a girl who's maybe just embarrassed about still communicating with an ex, maybe afraid it might make her boyfriend uncomfortable, and she's just deleting them, kind of cleaning it up as they're coming in. That makes certainly more sense when you consider reason and common sense than he's destroying evidence but then leaving a bunch of it behind. They hit the phone. I just threw it on there because Brett addressed it. Obviously, I take issue with that because the phone's not hid. The phone's in the house. It's in the apartment, as is virtually everything else, right? Screwdriver's in there. Knife is not. The bat is. The blood is. Taylor Escontrias is. Defendant lives there. It's just a weird call to be like, well, that's the outlier, right? He hid the phone in the apartment under some sheets like a child hiding from a monster. Count 2. This is the only point in time I'm going to address it, and I'm going to be swift. It's factually inconsistent. Count 2 talks about a domestic assault, but then at the same time, on the other side of the mouth, we're talking about a death. They're just inconsistent factually, and that's all I'm going to say on the matter. So count 2 is factually inconsistent. Murder 1, as I submitted to you already, is not a viable conclusion to reach. I take issue, obviously, with all the instructions, but I'm going to hyper-focus for purposes of this marshalling instruction, and it's going to be the portions of it that are in bold. So, defendant acted willfully, deliberately, premeditatedly, and with a specific intent to kill Taylor Escontrias. And it's been defined. Again, the instructions are exhaustive, but I'm going to just highlight a few. To deliberate is to weigh in one's mind, to consider, to contemplate, or to reflect. Now, that can happen by instruction in almost an instant, but it is still something you have to consider first. So there at least has to be some time span in order for you to consider what you are going to do next. Premeditate is to think or ponder upon a matter before acting. So very similar in nature, but I'd submit to you that is certainly the opposite of a reflex. Right? A reflex, you're not doing those things. You're not thinking, you're not pondering, you're acting. So again, those just stand out to me. Malice, again, just a portion of the full instruction, requires only such deliberation that would make make a person appreciate and understand the nature of the act and its consequences as distinguished from an act done in the heat of passion. And heat of passion, if you don't recall, is also language in the voluntary manslaughter instruction, and we'll get to that. But that's contemplated in the definition of malice that's offered. So I just want you to think of just an activity. Any activity. Doesn't matter what it is. And the question is like, once you're in it, are you just in it? Like, are you just doing it? Or are you kind of like, are you considering, are you then contemplating and recontemplating every step in that process? We'll treat it like a walk in the park, right? Are you contemplating each step, or did you contemplate the walk and then every step is not being deliberated and is not being premeditated? That is just happening. That is in the action that you're already in. Another example is just eating food, each bite. Are you contemplating each time, or are you just doing? Pedaling a bike, same idea as walking. Each step, are you contemplating, are you premeditating, or are you simply doing? So premeditation, if you're going to plan a murder, is this how you do it? This is how anybody would do it. I think the act itself, I think the evidence that the state has presented is illustrative to me. I just butchered that word, but I think you know what I'm saying, that there wasn't a plan. I think in essence it indicates the complete absence of one, because nothing makes any sense if it were planned first. For starters, what would we assume would be evidence? And again, this is where common sense and reason comes into play. There's no like textbook or testimony, certainly, that illustrates these are the things that are required for premeditation. That's simply not the case, but these are things you can consider when you're considering the evidence. Things that might be evidence of premeditation. Things like journal entries. And maybe not everybody keeps a journal. Maybe they just keep it like, I keep my notes in like a notes app on my phone. It's kind of like my thoughts. It's not an everyday journal, but just an indicator of my thoughts. Maybe it's text data, which is in many ways absent here. We do have messenger app data. We don't have any text data that, at least as far as I can recall. Google searches sometimes can be useful. We actually see them all the time on like crime documentaries and stuff. If any of you watch those, they'll just go back through the suspect's Google history and look for things that are indicative of, how to kill a person, how to hide a body, where to buy a gun, if it's a shoot, things like that. Some indicator that this is planned or premeditated in advance, and that is absent from this case. Any statements to others. So again, like talking to a mom, a dad, a cousin, a friend, a confidant, anyone at all that comes in and says, hey, he's been losing his shit for a while. This is what he's been talking about. I didn't take it seriously. I didn't think you'd do it, but here we are. Those are things that would be indicators of deliberation. And I think a weapon purchase, the next part on there just kind of talks about implements of convenience. Just so you know what I'm talking about, they're not things that wouldn't be found inside the home. In fact, these were things that would be found inside the home, not things that were like special purchases, like things that I went out to do. Like if I'm going to bury a body, maybe I go out and buy gloves and a shovel the day before, or even moments before. Some purchase indicating what act is to follow. No destruction of evidence. And I think that there's some debate between the parties about whether there was or wasn't destruction of evidence. I submit to you that there was not. To the degree he had the knife outside of the apartment, it was in the car next to him. I wouldn't necessarily define that as destruction of evidence. There's no use of water in the bathroom or kitchen. Maybe you didn't notice, maybe it doesn't mean anything to you, but certainly like a shower, an attempt to clean hands, an attempt to clean up the apartment, like those would be indicators of destruction of evidence. There's no testimony that he changed his clothes. I think even the shirt that he was wearing at the time, law enforcement took possession of him, or at least took his clothes from the hospital. He had a knife wound, or at least a wound consistent, strike that. He had a cut on his shirt consistent with a knife wound, which is an indicator that he kept the same clothes on. And he did leave. That was something that was brought up in closing statements by the state. I just want to say, if that does go to state of mind, and we'll get to state of mind in a moment, but if it does, just bear in mind it's the same state of mind that resulted in a vehicular accident with a non-moving entity, right? I think it was a concrete barrier around a lighting assembly. And that just seems inconsistent, I guess. This is more of the same, just didn't change clothes, didn't look for a weapon. I think that there's evidence to support if he changed clothes or was looking for a weapon, he would have tracked blood into the bedroom. Either his own blood, and we know he was bleeding because there's been testimony that he was actively bleeding from his abdomen, it was on his shorts and on his feet, or it would have been her blood, Taylor Escontrias' blood. Now this is just one image, one perspective, but there were various perspectives of that room, none of which show blood in that particular bedroom. More of the same. In the middle is bedroom 2. Again, it's just one perspective. There were multiple photos taken to cover the entire room, and there's no blood in there either. There was no blood in the hallway, which is indicated on the image to the right, which shows into the bathroom, I believe from bedroom 1, but don't quote me on that. And then the image to the left is the bathroom, which again, just showing that it was not used. I did not present a picture of the kitchen. The kitchen shows blood, obviously. We've seen it. It's right in front of the refrigerator, but the blood stops at a particular point, and there's no tracking to the sink. Now, there is a screwdriver there. I don't know how to explain that, to be honest with you. I don't know who put it there. Maybe it was moved by law enforcement just to get it out of the way. I don't know what it was. But the sink in that particular room in the kitchen was dry, as was... There was like a sponge on the left of the sink, and it was like curved up. Any of you who have sponges on the side of your sink, they kind of curve as they dry out. So we know that it was at least dry for some time. So the kitchen sink was not utilized either. Intoxication. The defendant claims he was under the influence of intoxicants at the time of the alleged crime. Now, intoxication is a defense only when it causes a mental disability which makes the person incapable of forming the specific intent. Again, unfortunately, some of these instructions, that is what they provide. You kind of have to make sense of them on your own. Some of these instructions necessarily don't always make perfect sense, but try to use, again, your common sense, your ordinary usage of terms, etc. Signs of impairment, just in general, these are things that were kind of, I think this is a conglomeration of different things that were said at different times throughout the trial. Some of them may just be reason and common sense, certainly things you may have seen historically. Those are slow or fast speech, which was present in Mr. Behal. The slow speech, I don't believe there was any fast. Difficulty finding words, speaking incoherently. I think it was Officer Leonard said that when he got there, he couldn't even make out half of what Mr. Behal was saying because he was incoherent. Issues of balance, I don't think we've seen. He was strapped to a board. I don't think he was really walking, at least at any point that we saw by way of evidence. Behavior can be altered, crying or moody, red watery eyes, lack of eye focus, smell of alcohol on a person, and blackouts. So some, if not many of these were present, some of these were absent for various reasons, but certainly all signs of impairment. So again, even if you have a tolerance, if you're exercising impairment, which I submit there's evidence to show, then you know your tolerance only goes so far, right? Like you're still under the influence, and you're still feeling the alterations. What's the word I'm looking for? Just kind of your altered consciousness. Evidence of Behal's intoxication. Some of these we already addressed. Some of them is memory. It's referred to as a blackout. I believe that was a testimony by Dr. Beall this morning. It is not saying that things did or didn't happen. It's simply saying you don't necessarily recall just because of the way that the memory is created, like sort of the transfer of information across the neurons. So recall is not an element. I think Mr. Larson had already broached on that, and I'm not here to tell you otherwise. Recall is not an element the state is burdened with proving. However, it does bear the question, or beg the question, forgive me, that if you're losing your memory, what other portions of your brain, what other functions are you losing? it strikes me as odd that part of your brain isn't functioning, but the rest of it, the remainder of it, is working with perfect function. And I submit to you that sobering up doesn't give that back. And I believe that was the testimony of Dr. Doyle, but I just ask you again to exercise reason and common sense. Maybe some of you have had a night where there's gaps, and I guess ask yourselves, frankly, do you get that memory back? And I submit to you that you don't. Further evidence of Beall's intoxication is the single vehicle accident. It certainly wasn't caused by someone else. It was his own operation of the motor vehicle. And there was no alcohol in the car, because we know he already drank at the apartment. The bottle was found there. The testimony is consistent with that. I don't think that that's really an issue. But just to be clear, he didn't drink in the car after he'd stopped. He was already under the influence of alcohol. There was slurring. There was vertical gaze nystagmus. And the only reason that that's there is to, again, be an indicator. I don't recall which law enforcement officer testified to that, but he said that horizontal gaze is one useful tool for them, and that vertical gaze nystagmus is an indicator of like extreme impairment. That was my recall of his testimony. So he uses horizontal, I think, as kind of a baseline, but then he also uses vertical to see how bad off the particular subject is. And he said that vertical gaze nystagmus was present as an indicator of extreme intoxication. We know the empty gallon of vodka, and we know that his blood alcohol content was confirmed by the hospital as being well over 300. This is kind of, again, a conglomeration of both Leonard and Doyle's. The useful portion from my perspective with respect to Mr. Leonard's testimony, or Officer Leonard's testimony, is he's an OWI instructor. So at least with respect to the intox, he's well versed. He teaches it himself. I think he said he's like a field training officer, but forgive me if that's not correct. So he has a ton of experience. I think 17 plus years law enforcement experience. And he said himself that over 300 blood alcohol content is very high. And he said that in his personal opinion, or at least in his experience, anyone over 300 is generally not even awake. They're unconscious. They're rendered unconscious by the amount of alcohol. And he said even with extreme tolerance, which was a question that was posed, like, what would that look like? And he said that they'd still be impaired, but they'd be awake. So they'd be up and about, but they'd still be very impaired. So even with an extreme tolerance, according to Officer Leonard, it'd still be impaired. And it impacts a person's ability to understand and to comprehend. I just want to touch on the Jekyll-Hyde thing. It came up during Dr. Doyle's testimony. I don't remember what the question was that it was in response to, but he says, like, some people, I'm sure you're all familiar with the story of Dr. Jekyll and Mr. Hyde. It's basically like I think he was we'll call him a scientist for lack of better words. And he created like a tonic or a potion that when he took it, he became like his alter ego. He was this large man, very strong, very, I think, angry and violent. That's the premise behind that. It just says that, at least the PowerPoint says, there's no evidence or indicators that he exhibited that type of behavior, at least not anything that's been offered by the state. And I don't think that there's any physical evidence to support that, and certainly you could see that differently. But what I'm getting at is, we know he's an avid drinker. We know he drinks all the time. There's been testimony offered to that. If he was freaking out every time, wouldn't there be like destruction of like stuff within the unit, right? Like, wouldn't the apartment be just in disrepair because every time he freaks out, he's putting his fist through walls or kicking doors or just destroying the property? That seems to be indicative of a Jekyll and Hyde behavior, which is not exhibited here. I submit to you what he offered law enforcement was not a confession. And there may be variance on what a confession is, even to you. But at least in just layman's terms, it's an acknowledgement of guilt. And that is not what I saw or heard in the evidence. Again, I'm not a fact finder. That's not my job. But what I heard is simply a man trying to figure out what the hell just happened. He has these moments in time, these flashes, these snapshots. I think snapshots, not videos, was the reference by Dr. Doyle. But he has these images he can't shake. He's got this, he's seeing these things happen in his mind that he himself doesn't feel himself capable of, that isn't making sense, that he doesn't think could possibly be true. But these are the versions he's given up based on these images that just are flooding his mind. The term that was interesting to me, a term I'm not familiar with, I hadn't heard before, but I think I've used in like a different way perhaps, is confabulation. Basically, what it reminds me of, some of you may remember this, some of you may not. I think there was this thing on Facebook, and I think it was actually a real study. It was like an Oxford study about sort of how our brains work. And if I recall correctly, they would take the first letter and the last letter of various words in this paragraph, and they just mix up all the letters in between. And basically what they found is some people can read that and their minds will correct all the letters and they can read it perfectly. And some people, their brains won't allow them to do that, so they can't interpret that script. This is kind of, I think, similar to confabulation, which is basically your brain doesn't like the gaps. It doesn't like the errors, so it fixes them. And what it does is it forces them, you imply your own form of logic to fill in the gaps. And I submit to you, that's what he's doing. He's got these flashes and he's trying to fill in the gaps. And he's trying to give the law enforcement some explanation. Now the video is long. I'm not going to play it for you. Thankfully, neither did the state, but you'll have access to it if you want to watch it. There's obviously a lot of significance to the video. There's a ton of stuff being said. I think that there's also some significance to the gaps. And the gaps I'm referring to are the times in which Deputy Rowling was not present. And he was talking to himself. And these are exact quotes. He says, "What the fuck? The fuck did I do? I fucking loved her. Fucking drinking has ruined my entire life. I don't know why I would have ever fucking killed her. It should have been me, not her. Why did this happen? I really hope," forgive me, I'm paraphrasing, "this was just a dream. Really just wake up at any point," and then you actually see him close his eyes and he opens them again. He says, "Wake up." And I just want you to at least remember those as an indicator, again, from my perspective, that he just is trying like hell to figure it out. And I submit to you that they're genuine. I haven't heard the state say it. Maybe they will, maybe they won't, that he's making all this up. But it just doesn't make sense, right? Like, what's the value in telling them all this stuff but then also faking it, right? Like, what exactly is he leaving out that he's capable of giving them? And I think that it's consistent with every person that he spoke to, at every time that he was spoken to. The hospital, he had no requirement to speak, guys. He didn't have to say a word. He's not required to, he can't be forced to. But he asked law enforcement specifically to turn off the beeping in the room so we could just have a conversation with the officer. And he asked that officer to check on Taylor. At that point in time, he knew something was wrong. He had these flashes in his head that he couldn't make sense of. And he's like, "Please go check on her." And that's what triggered law enforcement to start doing those wellness checks that night. They didn't do it on their own. There wasn't a 911 call placed. He directed them, "Call my girlfriend, check on my girlfriend." At the interrogation room, it is very evident he's trying to figure it out in real time. And even the parts where he's like, "No, that doesn't make sense," he would start over. I see it differently from the state, I believe, with respect to, he's not saying he made it, he said he made it up. But I think it's all, at least in some degree, made up. He's saying what he saw in his own mind, but he doesn't know the whole story, and he's trying to fill in the blanks, and he's giving them the information that makes logical sense to him. But he's clearly trying to answer the officer's question. Even the officer admitted, "I didn't interrogate him. He's just talking." This was just a casual conversation, and he's talking to the officer. And I think it's significant that he doesn't acknowledge the camera even a single time. If he's playing this up, which is an incredibly long game that honestly doesn't make any sense to me, but if he's playing this up, he's both the best and the worst actor I've ever seen. I don't understand sort of all the information he gave to then also be faking the rest. It's like believe part, ignore part. I have a hard time logically following that type of thing. And just bear in mind, no one's looking for her at this point. And why is that relevant? It's just relevant to, again, the genuine nature of it, because he could have very easily just been processed for his OWI and gone home. He started everything. He gave law enforcement a reason to go looking for Taylor Escontrias. Holland, Seaman, nobody reached out to law enforcement. They weren't looking for him at all. Murder 2. Now this is, again, what I believe is the ceiling. Murder 2 is the ceiling here. And what's relevant, and forgive me, the second bullet point, it says in element 1. I just didn't want to be incredibly redundant, but you have the marshalling instructions. The activity in element 1 it's referring to is the screwdriver, knife, and the bat. Okay? So I think we're on the same page there. And again, I just submit to you that there's insufficient evidence to conclude the planning, the premeditating, the deliberation that is required, particularly in light of his intoxication level and the evidence we've seen about that. Voluntary manslaughter. This is the floor. So the two options as I see them, and I submit to you. Voluntary manslaughter. Now again, I'm not conceding elements, but I am focusing on the bold script. And it says, stabbing and or hitting of Taylor Escontrias was done solely by reason of sudden, violent, and irresistible passion resulting from serious provocation. And I have to imagine this hasn't been something you guys have been thinking about, probably at least first and foremost because you didn't know the jury instruction, which you just got, I don't know, an hour and a half ago. But this is something I want you to seriously consider, and I'll explain to you why. So serious provocation is conduct that would cause a reasonable person to have a sudden, violent, and irresistible passion. Passion is not sudden, violent, and irresistible if there is an interval of time during which a reasonable person would, under the circumstances, have time to reflect and bring his passion under control and suppress the impulse to kill. Now, passion is not defined, so you have to use your ordinary common usage in that endeavor. Now, did he act with provocation? I submit to you he did, and I'll explain to you why here in a moment. But do not conflate this with justification. This is not a justification defense. That is not what I'm offering you here. Justification is self-defense. That is not what's been offered by the defense. There's requirements in order to provide evidence of such. It's not there. We're not saying this is justification. We are saying that this is provocation. Now, I submit to you Taylor Escontrias stabbed Christopher Behal in the gut. Now, it begs the question, what's more provoking than that? And I struggled very, very hard the last kind of day or so to think of a scenario that I thought would be more provoking in nature than being stabbed with a knife in the abdomen. The only thing I could come to, but I have no real life experience about it, is like threatening my children. I don't know shy of that, and maybe, obviously my wife, but really my kids, right? That's my job, is to protect my children. If someone threatened my children, that would set me off more than anything in this entire world. That would be provoking in nature. That would cause me to act. There's no question about it. But what's next in line? Now, we're not talking about sort of the metaphorical concept of stabbing me in the back, right? Like doing something nefarious to me that sort of breaks our relationship or what have you, our trust that we may have developed. But this is someone you love. It's the equivalent of a person's wife, right? At least for purposes of their relationship, that's kind of the way he thinks of it, I believe. And that person either looking you in the face or not and taking a knife and plunging it into your abdomen. And I ask you, what is more provoking than that, other than the things we've just described? And I submit to you that the evidence bears this out. First of all, he has the injury. There's no contesting he has the injury. And I submit to you that this happened first. Now, how do I come to that conclusion? Just with reason and common sense. I'm not an expert. I'm not a reconstructionist. I don't play one on TV. But there's no blood on the kitchen cabinet where the sheath was located. Now, I believe the testimony was that was essentially the knife in the kitchen. They didn't have a cutting block. I think Deputy Rolling said that there wasn't one there, but at least someone did. There was not a knife block. That was the knife that was in the kitchen. And there was no blood on it. So she wasn't bleeding. So at this point, there couldn't have been an attack. And the reason I say that is because we know that she was bleeding everywhere, right? We know that there was a ton of blood lost. So we know she's not bleeding when she reached for that knife. So it had to have happened first. We know that she, at least I submit to you, she couldn't have disarmed him. At what point? She's bleeding, she's drunk, she's injured, she's, I'm assuming smaller than him, although I guess there's no testimony that's been offered to illustrate that. And we know that he's bleeding because there's a mixture of blood in the apartment. So it didn't happen at some later time. It happened in the apartment. And again, the only logical conclusion is that she stabbed him first. Excess. What do I mean? I mean like an overreaction. I don't know. I didn't really know what a better word would be to use for that. And I just want you to think about a time that you've acted in excess. See, I can't even read my own PowerPoint. Just was there ever a time, a moment? And then I want you to think about, did those circumstances matter? Like, was there an emotional component that fueled that acting in excess? And I just kind of think about, again, my own personal experience and the one time that I acted in excess. And it wasn't to this degree. It wasn't, nobody was charged, anything like that. And it was a stupid, juvenile, it was a bar fight. And there was an incident with a girl that I was dating at the time. And this guy just acted untoward in a way that was, there was a lot of history that led to that. So it wasn't just a one-off. But we were at a bar, and he made the first move, and he hit me. And we fought. And I ended up on top, and I was probably there for much too long, to be honest with you. And friends and bar members grabbed me and pulled me off and dragged me out of the bar. And I was angry. I was embarrassed. I'm still embarrassed. I've never been dragged out of a place before. But I would describe that as an acting in excess. But I would not have reacted that way. In fact, I've never reacted in that way since, but for the emotional component. That this was involving a girl that I was young, and when you're young, you think they're all the one. So it mattered a lot to me, and I acted in excess. But I submit to you that people don't generally act that way when there's not an emotional component involved. Again, that's just my position. I submit to you that there's no evidence of self-harm. So any idea that he did it to himself is frankly laughable. How do I come to that conclusion? First of all, there's been no evidence that he's a cutter. Some of you may be familiar with what that term means. Some of you may not be. But if you are familiar with someone who cuts, think about where they generally cut themselves. Those are relatively superficial areas, usually areas that are easy to hide because they don't want others to know about it. They're not generally cutting life-threatening vessels or life-threatening areas of the body. Those people are suicidal. Cutters act out of depression, agony, self-loathing, things of that type. And we know that it was a stab, not a cut, because it was described as such. The expert, Klein, described it as a stab. He said the difference is if it's deeper than it is wide, then it's a stab. If it's wider than it is deep, it's a laceration or a cut. So this is definitively a stab. It was 2 to 4 inches deep, according to, I think it was Officer Raby, and 1 to 1.5 inches wide. The laceration observed on, the stab observed on Mr. Beall's. Again, it was described as kind of his waist, gut, abdomen, that area. We know that it was not caused by the car accident, and we heard Officer, I believe, Leonard, who testified to that he'd inspected the interior and didn't conclude that there were any sharp jutting pieces of plastic or metal that could have resulted in that injury. And we know Beall's right-handed. Again, not an expert. Don't play one on TV. But I am armed with reason and common sense. And think about if you stabbed yourself where you do it. It would be on the right side of your body. It wouldn't be on the left. It doesn't make sense. People don't stab across their body. Again, I'm assuming none of you have ever stabbed yourself on purpose, but if you've ever stabbed yourself on accident, your right arm doesn't generally go across your body. Now, if you were stabbed by a right-handed person, it would be on your left, which is consistent with where his injury was located. That was not done by Mr. Behal. That was done by Taylor Escontrias. Now, this is the part that sucks to talk about. I just use We're Going on a Bear Hunt. I don't know if any of you have ever read that book. I think it was like from the late 70s, early 80s. And as with every children's book, there's like a moral to the story or some lesson that they're trying to teach you. This is just a story about a family that are just going on a bear hunt, right? It's a fictitious bear hunt. They're taking a walk, really, is what they're doing. And they come to different points, different obstacles. They're meeting adversity in different ways. And really the moral of the story is essentially like, when you reach adversity, sometimes there's no way to do it, like to go through it, but to just go through it. Sort of the idea that you can't go around adversity or under. You just got to kind of, drop your head and just go. You're just going through it. So I'm going to present to you what is the defense theory. And it is just that, a theory. But I believe when you exercise reason and common sense, you can reach many, if not all, of the same conclusions. I think in many ways what the state has offered you so far is really just state's theory. They just don't call it that. That's fine. On the right is Exhibit 49. That was a diagram that was drawn by Officer Grease, or Greasy, I'm not sure. I might be messing his name all up. The image on the right is just, I guess, to give you an idea of where things are taking place. I submit to you the incident begins in the kitchen. I submit that to you based on the copious volumes of blood that were found there. It just doesn't make sense, again, why would the blood be there if not that that's where the incident started? I submit to you it's at this point in time, they're having a discussion, maybe a fight, who knows. Taylor stabs Behal in the abdomen. And I submit to you that there's no scenario that supports that this happened later in time. And we know, again, implements of convenience. We know that the screwdrivers were kept in the kitchen. We know that the knife was kept in the kitchen. We know that the bat was kept somewhere in the apartment. I don't think that there was any definitive testimony about where the bat was, but they were all, I submit to you, within a small area within that apartment. And again, the reason I say it is because there's no blood trails in B1, B2, or the bathroom, or the hallway. So everything that was grabbed at any point in time during this incident had to have been within this kitchen right in front of the fridge to the living room. That's what at least I believe the evidence shows. We know that, again, he's bleeding, so he's not bleeding in B1, B2 in the bathroom, so there's no evidence that he went there. Now, it's my theory, it's our theory, that she stabbed him and he hit her. I don't know with what. I think sense makes that it was with the baseball bat, but that it was instant. It was a reflex. I got stabbed, I have an impulse, I strike her. Now, why do I come to that conclusion? I submit to you that any person struck in the head with a baseball bat is probably rendered immediately unconscious. There's not been any testimony, expert testimony to that, but again, use your reason and common sense. And not only is she, the skull's just not made to withstand that type of force, but she's also under the influence of alcohol. And I submit to you she goes down. It's one hit, it's likely to the front, she goes to the ground. I submit to you when she hits the ground, she fractures her jaw. Dr. Klein testified that a fall from standing could fracture your mandible. And at least with respect to the x-ray, I didn't see, again, I'm not an expert, but it is reasonable that she fell and broke her jaw in that moment. And I submit she never regained consciousness. I don't know if it was from the bat. I don't know if it was from the alcohol. I don't know if it was from a combination of factors. but she goes down and she doesn't regain. And the reason I submit to you that that's the case is because all of her injuries were to her back, at least almost all of them, which means she's already down, likely out, likely unconscious. If she were fighting or if there was an elongated incident, a back and forth, I submit there'd be more injuries to her front, injuries that could be described as defensive in nature, and they just don't exist here, at least not in my recall of the evidence. We know that she's bleeding a lot in that kitchen, again, as evidenced by the photos that we've all seen. And there's been testimony by the expert Klein who indicated many of those would have resulted in death. I don't recall that he said specifically which ones, but he said that there were various injuries that she sustained that could have resulted or would have resulted in her death. Now, again, I hate to be redundant, but why I come to this conclusion, why I submit that's the case to you, is just the sheer volume of blood. And she's intoxicated, so she's going to bleed a little faster. If any of you have ever been under the influence and bled, even just a small finger prick, you bleed a little bit faster, your blood's a little bit thinner. And again, the knife and the screwdriver were located there. I submit to you the incident was very short in duration. I know that there's an argument to be had that maybe it took a lot of time, but I don't think the evidence supports that. I think it happened very, very quickly. Because had she have been screaming, had this have been carrying on, I think it would have got someone's attention. The downstairs neighbor heard a few things, but nothing that got his attention. I think he put his headphones back on and continued listening to his TikTok videos. And I don't know if there were other residents, but this was a fourplex, so there were at least 2 other apartments, whether they were vacant or not, but none of them testified if they were even home or awake. But had this have been an elongated situation, I would imagine somebody would have been kind of, I guess, aware of it. Again, this is why it's difficult to kind of talk about, because this sort of notion of adversity. I think the incident happened in the kitchen. I think she died in the kitchen. I think that that's what the evidence supports. I think it happened fast, and again, I think it happened in the kitchen. I submit that to you because I don't believe the evidence supports she could have gotten anywhere else under her own power, based on sort of what Dr. Klein had testified about. And there's no blood pattern, which is a little, maybe that's not unusual, maybe it is, I don't know. But there's blood in the kitchen, and then there's not really any blood till she's at the doorway. I can't make sense of that unless somehow she were moved, which maybe doesn't make a whole lot of sense to you. But if she were walking or crawling and actively bleeding, there'd be a trail, and it just doesn't exist. I think the only blood between the kitchen and the living room was like a smear or a brush on the recliner, which could have very easily just been Beall when he passed through. Now, any offenses that occur after someone is deceased is not murder in the first, murder in the second, voluntary or involuntary. It's just not. You can't form intent after the fact. That is a separate crime and a crime that has not been charged. That is an offense with, it's referred to as abuse of a corpse, which basically means that there's damage to a dead body. That is not any of these offenses. That is a separate offense, and I believe something happened, obviously, by the door. I think that there was like some spraying, if you will, or like, I don't remember the term that they used, but there was evidence of blood like on the door. But again, I submit to you she was long dead at that point. Maybe long is an inappropriate word, but certainly already dead at that point. And I come to that conclusion, or at least I submit to you that that is the case based on reason and common sense, because there's very little blood found in front of the door. If any of you have ever done any plumbing at home, you're kind of familiar with this concept, which is if there's a break in a pipe while your water is on, right? And by on, I just mean the main is open. you could flood a basement. Like it'll just kind of keep coming and coming and coming and coming. But if you have that same break in the pipe and you turn the water off, right, it'll still come, but only whatever water remains in those pipes, right? Does that, maybe that doesn't make sense to those of you that are familiar with it. It will make perfect sense. The idea being you don't continue to bleed after you die. I submit to you that the very small pool of blood that exists near the doorway is just gravity taking place. It's just whatever residual blood comes out post-mortem. Reasonable doubt. The state is burdened with proof, so I just ask that you make them prove it, right? It's really that simple. That is my ask here. Instruction 42 indicates that your sole duty is to find the truth and to do justice. That's your job. You, I think, will have a natural inclination to blame. We talked about this a little bit during the jury selection process. It's natural. We all have it. And you can still blame him under the options that I submit to you that you have available. You can blame him for everything with the options that I submit to you remain available. I just ask that you only convict him to the degree that he is legally culpable. That's all I can ask you at this time. And with respect to the verdict, I just ask that you find him guilty of voluntary manslaughter under count 1. And again, I submit to you the basis for that is the fact that he was stabbed first. The evidence supports that. There was no stabbing after she was struck. I submit she was not capable. So she stabbed him, and he acted out of impulse. And that is what the evidence shows, and that's what I ask you to find. Thank you.
May I see counsel at the bench, please? Ladies and gentlemen, due to the late hour today, we are going to adjourn for the day. I would ask that you come back tomorrow morning at 8:50, and we will begin promptly at 9 o'clock with the remainder of the case. I would remind you of your admonition. Please do not discuss this case amongst yourselves. Please continue to keep an open and attentive mind, and I will see you tomorrow morning. Thank you.
All rise for the jury.